The hearing, United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. We have 5 oral arguments set for today. We'll take at least one break and perhaps 2, which will be announced at the time we take the break. I noticed that there are a couple cases where the argument is planned to be divided by one side or the other, and attorneys generally like to reserve some time for rebuttal. That's always problematic. We may ask a lot of questions, and so there's not any time left for rebuttal. And dividing time among attorneys on the same side is always difficult. So please be aware that you may be encroaching on a fellow attorney's time, and we'll see what we can do. We'll start with 18-6102 and 18-6165, Tudor versus Southeastern Oklahoma State University. We have 20 minutes to a side assigned in this case, and I believe Appellant wants to share 5 minutes with amicus. So we'll see about doing that. So Ms. Weiss, I think you're first. Shall we go?
Judge Hartz, and may it please the court. I'm Jillian Weiss. I represent Dr. Rachel Tudor, who received a jury verdict in her favor, finding that the university and the regional university system of Oklahoma engaged in sex discrimination when it denied her tenure, and engaged in sex discrimination and retaliation when it denied her an opportunity to reapply for tenure. The major issues we'd like to address here are 3. First, she moved for reinstatement, which was denied, primarily based on error of fact because of alleged hostility, which is not based in the record, which boils down to the university saying, we don't want you here. Second, a remittiture was granted from $1.2 million to about $360,000, primarily because of errors of law regarding statutory caps and mitigation. And third, front pay was set at about $60,000, which is based on errors of both law and fact. I will discuss the first 2, and my colleague, Ms. Erica Lai, representing National Women's Law Center and other Amici, will address front pay, and we're requesting that this court order Dr. Tudor's immediate reinstatement with tenure, which is the only remedy that can honor the jury's verdict. Now, with regard to reinstatement, the court below abused its discretion because there's no record evidence of hostility. The hostile work environment count was defined by the jury. She wants to go back. Everyone who's had a problem has left, and the university now has some of the best transgender policies anywhere. They explicitly agreed to protect Dr. Tudor in their compromise agreement with the Department of Justice. And the court below failed to consider some important special circumstances of Dr. Tudor being a fully enrolled member of the Chickasaw Nation of Oklahoma, specializing in Native American literature of Oklahoma at a Native American serving college on Chickasaw land, who had to move to Texas to find a job teaching in a 2-year community college, and now has been banned by the Oklahoma Attorney General from any Russo institution because she won her jury verdict. As this court said in Jackson, reinstatement is the remedy that is required except in extraordinary circumstances. Those circumstances do not exist here.
Does that change?
Go ahead, Carol. You go ahead.
Does that change when we're dealing with reinstatement with tenure? Do the courts get involved in deciding who should get tenure?
Oh, yes, they absolutely do. And a number of them have done so. Most notably, the First Circuit in the Brown decision, in which they said that the university's right to grant tenure and freedom is not give them the right to refuse tenure based on sex. So there have been many cases of that nature.
Ms. Weiss, along that very same line that Judge McHugh asked, I was intrigued that on your you made a statement that we could consider an alternative of reinstatement without tenure. Tell the panel how that plays out. Is that something you are urging us to consider as an alternative, or it just kind of popped in there in the reply brief? And I'd like to know how you're standing on that, given that Judge McHugh's already raised the tenure question.
Well, reinstatement without tenure would be equivalent to reinstating her on probation, which would not be suitable, as this court has said previously.
Well, and yet your reply brief said that would be an acceptable alternative.
Understood. And the court may feel that for whatever reason, they do not wish to reinstate her with tenure. However, we would urge that with tenure is the appropriate remedy.
I understand that. If it was reinstatement without tenure, what would be the future of your client? Because don't they have an up and out policy? If you aren't tenured by 7 years, you're out. So wouldn't she still, if we had reinstated her without tenure, wouldn't she still be then up against the up and out policy? Or is this presupposing that the university would waive that policy as to her?
Well, certainly since the university had incorrectly applied its policy in the first place, it would have to remedy that by allowing her sufficient time to regain that tenured status.
That is, to apply for it.
Certainly, if reinstated without tenure, she would have to apply. But we
and so you would
that she's qualified. Oh, I'm sorry.
And then they would make the decision on tenure at an appropriate time that would be fair for everybody. That's not your preferred desire. I totally understand that, and we're going to apply the law. I just was intrigued that kind of popped in the reply brief, and I wanted to just ask you about it. So you proceed with your argument.
Well, certainly, and part of the reason why that issue was brought up is because there are some special circumstances here that are extremely important. The Supreme Court has said that the most complete relief possible must be afforded to a victim of discrimination in Albemarle Paper Company versus Moody. She is, as I mentioned, a fully enrolled member of the Chickasaw Nation. Her people had to endure the Trail of Tears. Southeastern Oklahoma is the homeland of the Chickasaw people. Southeastern is within the historic boundaries of the Chickasaw Nation. And as Dr. Tudor herself has written in her scholarship, it is a special place with no equivalent. This allows her to serve the Chickasaw directly. And she had to relocate to Texas, which really was something that moved her out of her historic homeland. It's a Native American serving institution under federal law. And the Supreme Court has recently, I'm sorry.
Well, I was going to ask you one other question because I'm just concerned about time. It's not on this point, but please, just very quickly, just give me a short answer. I won't ask a follow-up. But if we agree that the cap, not the salary cap, but the damages cap applies, does that moot a lot? And if we decide not to do reinstatement, does the damage cap moot a lot of your other damage calculation arguments? Doesn't it cut out a lot of those other claims?
The damage cap was incorrectly applied. And is that the question you're asking?
I'm asking you to assume for a moment that we feel it should have been applied, that it was correctly applied. If we agreed with that, then does that moot or abrogate a lot of your other damages arguments on calculation of amount of damages?
Well, it doesn't, because the back pay was incorrectly calculated, and it should have been about $228,000. The court awarded about $60,000.
So your back pay would not be mooted by the salary cap. I mean, the damages cap, but everything else would be. Is that correct?
Everything else, meaning what?
All the damages claims, any other damage calculation for front pay.
Well, no, front pay is completely separate. Front pay is outside of the caps, and we know that. So regardless of the application of any caps to back pay, which it shouldn't have been, front pay has nothing to do with any caps.
So you believe that the damages cap has no impact on your other damages arguments?
Yes, that's correct. With regard to front pay, for example.
Right. No Thank impact. You. Yeah, you proceed. Thank you.
Ms. White, when you began your argument, you stated that the denial of reinstatement by the district court was based on incorrect fact findings without evidence, essentially. What about the testimony by Randy Pruce Ms. Tudor seemed to think that she had no problems with him personally, did not think he was bigoted. And yet he said that at least half the faculty opposed her possible return. They didn't have the money for another position. How do you respond to that testimony? And correct me if I've mischaracterized the testimony.
Well, I would say that his testimony is different from what you just stated, Judge Hartz, because what he said in the Dr. Tudor's appendix at volume 8, page 9, was that he believed that few people would object for a variety of reasons. But he didn't say anything about hostility or what their reasons were. He himself said he had no problem with Dr. Tudor, and he even said she was qualified for tenure in 2010, 2011. So that is based on an incorrect understanding of his statements. And many other people there indicated they would welcome her back. As a matter of fact, the American Association of University Professors chapter at Southeastern wrote a letter requesting her reinstatement just recently. So, that issue of is there hostility and do they have money for it? Well, they were advertising until recently for a position there. I mean, this isn't in the record, obviously, but, the question of do they have room for Dr. Tudor? They do. But more importantly, when we think about, what should be done with regard to reinstatement, the offer of reinstatement on probation, which would be equivalent of not granting her tenure, would be unsuitable. That's why the Collin Community College job was unsuitable.
Let me ask another question about hostility. The judge also based his decision, as I understand it, you can correct me again if you think I've misstated it, is he thought that the tenor of the litigation indicated such hostility that it would be hard for them to work together. That both sides had said very nasty things about the other. Maybe I'm reading between the lines there. But how do you respond to that?
Well, what Judge Courtroom referred to below was what we call litigation adversity, as this court knows from the example in Jackson versus City of Albuquerque from '89. The fact that credibility attacks or adversity or making arguments against the other side occur, that is a natural byproduct of any litigation, as the Eighth Circuit noted in Taylor versus Teletype in 1981. And it has to be irreparable acrimony that rises to the level at which the parties' relationship is irreparably damaged, as the Fifth Circuit recently said in Bogan versus MTD Consumer Group. And in Jackson, for example, if you look at that situation, there was unprofessional and derogatory language. There was burglary of a file from an attorney's office. There were comments in the newspaper after the trial. There were threats of further litigation. And yet the court said, you must reinstate. That is required and except under extraordinary circumstances. So simply the fact that there was some back and forth between the parties, certainly there were heartfelt positions, but the university's cases do not support their position. In those cases, the professors were disapproved at the department and all college level. Here we have a professor who was approved by all the professors in her department, it was approved by the all college committee, and when it got to administrators, she complained, and so they said no tenure. That's what the jury found. And so, for example, Villanueva that they mentioned from the First Circuit, Broussard Norcross from the Eighth Circuit, Ford v. Nix from the Sixth Circuit. All of these involve situations where the professors were not approved by anybody. So, that is not really a consideration from our point of view. I would like to reserve some time for rebuttal and some time for my colleague to discuss front pay. I'm happy to answer any other questions, but if not, I will just make a short closing and allow counsel for Amici to speak. So the points that I would like to make in closing are that essentially the university wants to relitigate the jury verdict. The jury didn't buy it, and neither should you. Reinstatement is a basic element of the appropriate remedy in wrongful employer discharge cases, and except in extraordinary cases is required, Jackson versus City of Albuquerque. The actors who had caused the problem are all gone. An offer of reinstatement on probation, i.e. without tenure, is not suitable employment. And the caps, if they apply, were improperly calculated because the back pay should have been about $228,000, leaving a non-pecuniary damages of $937,000. This is based on the associate rates that she should have received and benefits, plus the removal of her back pay from the time she left Collin Community College until the date of the verdict. It was an error of law to determine that those Title VII caps were unwaivable. They never raised them in any of the many answers that they brought up. And you can see information about this at Dr. Tudor's appendix in volume 5.
Let me interrupt you on one point, please. Did I understand you to say that the loss of pay until the verdict is all considered part of back pay, not front pay?
That's correct. Right? Yeah, that's clear from the Supreme Court's ruling. So the last point I'd like to make is that, as this court said in Jackson, sometimes money cannot make one whole. Money cannot cure Dr. Tudor's ejection and exile from Oklahoma. Thank you.
Ms. Is it Lai or Lay?
Lai. Yes, Your Honor. May it please the court, Your Honor. Erica Lai from Cohen and Gresser on behalf of Amicus Curiae, the National Women's Law Center, which is supporting Dr. Tudor in this matter because it has an interest in ensuring that plaintiffs that win jury verdicts on gender discrimination and retaliation claims are awarded complete relief. We are weighing in on only reinstatement and front pay. As to reinstatement, we agree with Dr. Tudor for all the reasons discussed by Ms. Weiss, that this case simply does not present such extreme hostility as to render Title VII's presumptive remedy infeasible. Even if front pay were the appropriate award, the district court abused its discretion in awarding only 14 months for the time period between Dr. Tudor's termination from a tenure track role as a professor at Southeastern and the non-tenured contract level position that she had at Collin College. The district court failed to consider 4 critical factors. First, the overwhelming evidence that the Collin College teaching position was substantially inferior to the tenure track position that she had at Southeastern and should not have been used to cut off front pay. Second, the lack of
your idea of determining whether they found a comparable or adequate job. I can buy that when we look at economic matters, like was it a comparable pay? Was it comparable tenure for her pay? But when you ask us to get into subjective things, like was it this comparable reputation? Was it a comparable sized office? Was it comparably located with Indian tribes? All of those things, I don't know that there's case law that really warrants or at least compels us to consider a lot of those much more subjective and hard to quantify factors.
Well, Your Honor, I think what you're getting to is that the front pay analysis is necessarily one that is predicting the future and how long Dr. Tudor would be working in the future, when she would be able to work, which merely emphasizes just how much reinstatement is the preferred and presumptive remedy under Title VII, as it's the only way to make her whole and to make sure that she is, in fact, awarded a remedy that fully accounts for the discrimination that she suffered. But even insofar as one looks at compensation, the salary that the district court took into consideration was only the salary that Dr. Tudor had prior to obtaining tenure, which the jury had found that she would have received had she not been discriminated against on the basis of gender. Her salary, as the record shows at volume 4, pages 217 to 21, would have been in the neighborhood of around $74,000, and that would have been much higher than the ultimate salary that she had at Collin College.
But you have a problem. She made a statement about a smaller salary amount that the district court relied on. Isn't that right?
Yes, Your Honor. Although the calculation that ultimately supported that showed that it was only a calculation for a shorter time period than a full year, which is what the district court should have taken into account and really looking at a comparison of the salaries. But even objectively speaking, even a surface consideration of the Collin College position relative to the position that she had at Southeastern shows how vastly inferior it is, given that it was not, in fact, a tenure track position. The record is clear in this case and has been well recognized in other cases that tenure is, in fact, the ultimate milestone in an academic's career. It enables not just a salary bump, but also job security. It makes an individual much more marketable. The status of it is significant. It involves scholarship and service as opposed to the Collin College position, which was only a teaching position, which were all reasons why the Collin College position should not have cut off the front pay award. But in addition, there was the lack of substantially equivalent work opportunities in Dr. Tudor's geographic area, the job market realities, which really make it much harder for an older Native American woman who is transgender to find comparable employment, and the black mark that now Dr. Tudor has to overcome from the discriminatory denial of her tenure. For all these reasons, Your Honor, the National Women's Law Center and the more than 30 women's rights groups that have weighed in our support urge this court to vacate the denial of reinstatement and order Dr. Tudor reinstated with tenure.
Let me ask you a question. You mentioned the black mark of the denial of tenure. Wasn't that erased by the jury verdict, that black mark?
Well, no, Your Honor, because now, even now, when Dr. Tudor applies for jobs, she has to explain why she was tenure track, but did not, in fact, receive tenure at Southeastern as she's applying for new jobs. That is still a black mark on her resume that needs to be explained. And it makes her much less marketable, Your Honors. I see that our time is up. Thank you, Your Honors.
Thank you. Okay, we'll turn to Appellee. Mr. West, you may begin.
Good morning, Your Honors, and may it please the court. President Minks denied plaintiff tenure and the opportunity to reapply. Yet throughout this case, plaintiff's theory has been that former Vice President Doug McMillan was the bad guy. In closing argument, plaintiff's counsel remarkably stated that, frankly, you'd think that a true man of faith might just come out and confess to doing the obvious, essentially calling McMillan a religious fraud for not admitting his guilt.
McMillan's gone now, right?
Yes, Your Honor. Aside from that statement being incredibly inappropriate and inflammatory, defendants believe that this quote actually illuminates the fatal flaws of plaintiff's case in nearly every aspect. It first shows that plaintiff lacked actual evidence by trying to make an assertion based on a lack of evidence. It shows that plaintiff utilized improper evidence by, among other things, attacking McMillan's religion repeatedly, and that plaintiff focused on the wrong person rather than President Minks without seeking to... Oh, sorry, Your Honor.
Counsel, you say attacking McMillan's religious preferences repeatedly. Was there more than just that one statement that you're referring to?
Yes, and it's actually been repeated on appeal. Plaintiff has called...
Let's talk about at the trial.
Yes, at trial, plaintiff called McMillan's religious beliefs, I believe, peculiar, and then also elicited very misleading testimony that indicated somehow that he was making employment decisions based on his religion. And then when it turned out later on cross-examination, those mysterious employment decisions were his helping a widow find a job. And so essentially plaintiff was trying to use that to somehow prove religious-based discrimination here, the simple fact that McMillan used a widow to find a job. And then at another instance, plaintiff then had the temerity to attack McMillan on the stand and say, basically, you're the one accusing McMillan of having brought up his religion when it was plaintiff that injected it into the testimony in the first place. This is
plaintiff's counsel you're talking about, right?
Yes, Your Honor, and that is true.
Let's focus on, you have a jury verdict that says that your client denied Dr. Tudor tenure on the basis of sex because she was transgender. So what you're arguing now to me seems to be a red herring. It's a very small part of a very big transcript. And I want to get to the issues that are before us on appeal here. Why isn't it appropriate to reinstate Dr. Tudor where the jury verdict is but for the discrimination, she would have tenure now at this university?
Your Honor, with respect, we would assert that the religious attacks on Dr. McMillan are not a red herring, and in fact are part of the underlying holding of the district court that reinstatement was inappropriate because of hostilities. And in hostility,
just to move this along, I agree completely with Judge McHugh, and it would be helpful, at least to two members of this panel, if you would get off that horse and move on to something else.
Well, Your Honor, I don't think I can get off the horse because that's one of the hostile acts.
Go ahead.
Yeah, that is one of the hostile acts that underlies the district court's holding on reinstatement. The district court held that there were mutual hostilities in this case, which distinguishes that from Jackson. The Jackson case that plaintiff repeatedly cites found that there were one-sided hostilities. And then also the Jackson case didn't have anything even remotely resembling Randy Pruss's testimony, as Judge Hartz has pointed out, where Randy Pruss was testified by both sides to be honest and trustworthy. And Randy Pruss has stated that for a variety of reasons, including the fact that half the faculty oppose reinstatement, that it would be bad for everybody involved. It would be negative for the university.
Dr. Press testified, Dr. Press said that Dr. Tudor qualified for tenure, correct?
Partially correct, Your Honor. Dr. Press testified that Dr. Tudor did not qualify for tenure in 2009 and 2010, which is why he voted against it. He testified that as of 2010 and 2011, Dr. Tudor had qualified, but then in his affidavit, and as defendants have pointed out, and as the district court held, in his affidavit, Dr. Press again emphasized that his initial decision was that Dr. Tudor did not qualify. And so at the
end of the day, Dr. Press said, I say she's qualified. Dr. Tudor is qualified for tenure.
In 2009 or in 2010, 2011, we are now 9 years later.
Dr. Press was one person who testified. There were also 6 current Southeastern professors out of a total of 12 in the department who all testified that they would welcome Dr. Tudor back and did not see any problem with bringing Dr. Tudor back. Dr. Press outweighs all the other testimony.
Your Honor, that coalesces perfectly with Dr. Press's testimony. Dr. Press's testimony was that about half the faculty opposed reinstatement. So the fact that Dr. Tudor is able to come forth with statements from about half the faculty potentially supporting or neutral on reinstatement completely coalesces with his testimony that about half the faculty oppose it. And again, Dr. Press's undisputed testimony in terms of his honesty and trustworthiness is that this would be bad for everybody involved.
Let's talk about that. Is that a hearsay problem? Was there a hearsay objection raised? I mean, how can he testify what half the faculty believes?
Your Honor, your first point is exactly correct. In the reply brief, plaintiff stated that this was hearsay, but there was no hearsay objection made below either in trial or to the affidavit. If you go look at the trial transcript.
Okay, so that's why that came in, because no objection was raised.
There was no objection. Okay. Now, defendants would say it's not hearsay, but at the minimum, there was no objection.
Okay, that answers my question. Thank you.
Okay.
Let me ask you this. If the goal of the statute is to make Dr. Tudor whole, and we have a jury that has found that Dr. Tudor was denied tenure because of discrimination, how can we make Dr. Tudor whole without reinstating Dr. Tudor?
Respectfully, plaintiffs or defendants would point out that we believe that the district court's decision was that Dr. Tudor was made whole by a $300,000 jury verdict and then a $60,000.
Or was a $1,000,000-something jury verdict, right?
Yes, which went far beyond the agreed upon statutory cap that both sides agreed upon. But the district court's finding was that essentially $500,000 did make plaintiff whole, especially in light of the fact that plaintiff did have a substantial employment within 2 years at Collin County and worked there for 4 years and lost that job due to no fault of defendants whatsoever.
How do you get around the fact that there is a strong statutory and judicially recognized presumption of reinstatement here? And the reason for it is because there is so many nuances that cannot adequately be accommodated by a damage award.
Your Honor, defendants aren't trying to get around that as much as just say the district court didn't abuse its discretion in denying reinstatement, having seen the hostilities here, such as the religious attacks.
Well, if we look at discretion, the discretion the district court said was that there was too much hostility. And if we were to look at this record and say that the only evidence of hostility now was litigation stress, and that's normal in almost any litigation. Do you have any? I mean, I think that if there is no evidence to support that finding, that would not be a difficult call to say abuse of discretion.
Your Honor, there is evidence for the finding. Again, going back
outside of the litigation, what evidence is there outside of litigation? There is a hearsay statement that some of the faculty would not welcome it, but that's not a statement that they wouldn't deal with her, that they wouldn't work with her, that there would be so much hostility they couldn't teach. That's none of that.
Your Honor, it is a statement that this would be, again, from an honest arbiter who plaintiff is called honest, saying this would be negatively affect the students, the university, and the faculty. And again, the faculty here, this is testifying from faculty that were not implicated at all in any of the discrimination accusations. So this isn't the case where Dr. Press is testifying about people who were implicated in discrimination. This is Dr. Press testifying about the faculty itself, saying that it would be negative, it would negatively impact everybody. And defendants simply would point to like
a statement that would be negative is not responsive or equivalent to what the law requires, which is evidence of severe adversity in the relationship. Even if we accepted that statement in its full force, it simply doesn't meet the legal standard.
And the district court here made a finding that there were severe hostilities present throughout the case.
Based upon a single statement, basically, based upon litigation conflict and a single statement that there's a certain number of faculty members that would not welcome it.
Based upon the testimony of somebody who's honest and straightforward with Dr. Press. And to get back to your point, well, if the presumption is reinstatement, then how can this happen? Well, the 10th Circuit has denied reinstatement multiple times in the past on this ground, and we would point to...
Well, let me jump in there, because in those cases, the person who was discriminated against was the person arguing against reinstatement as a remedy. It was actually the victim of the discrimination who wanted damages instead of reinstatement. To me, that's a big difference.
Your Honor, respectfully, we disagree, because in the Sterrett case, and this case was cited in Jackson, the Sterrett case, this court held that reinstatement could be denied in that instance based on a case like Press of a single witness who testified that reinstatement would have negative effects. That was the Sterrett case from right around the same time as Jackson that was cited in Jackson.
If we go this route, people can discriminate with impunity and then say, we don't have to honor the tenure decision that was denied only on the basis of discrimination because we don't want to work with this person. Doesn't that just reward the discrimination? It takes all of the teeth out of the statute.
Respectfully, Your Honor, we would argue the opposite. If you force and say that this is an abuse of discretion here, not just de novo review, this court could very well come to the opposite conclusion. But to say that the district court abused its discretion by relying on somebody as honest and trustworthy as Randy Press.
Well, are you saying the other 6 professors weren't honest and trustworthy when they said we'd welcome her back?
Well, that brings up a good point that I wanted to get to, Your Honor. When you claim there are 6, when the plaintiff claims there are 6 professors, there was only 1 or 2 of those at trial. 3 of those were submitted in affidavits in a reply brief below, which is inappropriate, and the district court did not consider them. So I wanted to make that point as well, that there was 1 or 2 professors who testified below, and as the district court found, Professor Cotter Lynch's testimony was not based on actual knowledge of the plaintiff's teaching and various other things. But nevertheless, my original point was that if you say it's an abuse of discretion to rely on Randy Press's testimony here, as well as the hostility the court itself saw, there's virtually no case in which reinstatement could ever possibly be denied. But that doesn't coalesce with this.
You rely on litigation hostility. There is probably never a case where reinstatement can be awarded, because when people are litigating each other in a hotly contested matter, there's typically litigation hostility because lawyers aren't saints.
Yes, Your Honor, but that's why we're not relying solely on litigation hostilities, but also on Randy Press's testimony. And one issue, and one factor that we haven't talked about is the district court also agreed with and made some findings of fact regarding defendant's belief based on post-2010 activity of plaintiff, that plaintiff had not maintained anything close to the level of academic performance or scholarship that would merit coming back, and not in relation to the pre-leaving of Southeastern by plaintiff. But the district court also put stock in that, and that is backed up by the record, especially by the Collin County record, which defendants can look at and have looked at and said that is not a good sign of being able to bring somebody back. The plaintiff lost a job at Collin County due to poor teaching and poor handling of students.
I thought that the test, the only test that we have to address, if we decide that the law says the preferred remedy is reinstatement. And we have to honor that unless adverse hostility is so extreme that it's not feasible. And now you're trying to say, well, unless two things, unless the hostility is extreme, which you think you've got evidence about. And then secondly, we should take another look at whether they would just hire her in the first place, whether she's maintained scholarship that she's currently valuable. But that second point really isn't part of the legal test for reinstatement, is it?
No, respectfully, Your Honor, we would disagree. The Acree case, ACREY, from this court in 1992 stated that, quote, absence of mutual trust, and then, quote, basically denied reinstatement because of an absence of mutual trust, or said that could lead to a denial of reinstatement. And also that in that case, the record contains examples of sharply conflicting evidence about specific incidents reflecting on plaintiff's job performance. So the case,
but there's nothing in the statement, in the language that you've cited in Acree, and I admit I haven't read that, but what you've cited, there's nothing in there where the court said that you look at not only hostility, but you also look at whether they would have rehired this person just based on the current day merits or not. You know, her life after she was denied tenure was turned upside down, and to expect that she would keep up normal scholarship when she didn't have a university anchor to support that is probably not very fair.
Well, going back to Acree, Your Honor, it actually does explicitly say that there was sharply conflicting evidence about specific incidents reflecting on plaintiff's job performance.
When? Before or after she was terminated?
I believe in Acree that was for after, but I would have to look back at the full.
Yeah, okay, well, that was the point. Unless you know that, how can you cite that case to us? So I'm going to take your statement as simply, here's another case I've drawn that you might look at. I'm not going to consider you're advocating that at all for your proposition here, unless you can assert to the court that the court said, we look at post-termination conduct on whether the reinstatement is an appropriate remedy.
Well, again,
and let me jump in on Acree. Acree's another one where the discriminated against employee was asking for damages instead of reinstatement. Correct?
I believe that is correct, Your Honor, which is...
Well, that's a huge difference. I mean, you know, if you've got the person who's going to be reinstated saying, please God, don't reinstate me, it will be a living hell, the court should consider that.
Yes, Your Honor, and that's why we have not cited Acree as our primary case in terms of looking at the Starrett case is why we have cited a case where the district court denied reinstatement because one of plaintiff's own witnesses testified that it was a bad idea. We just simply point out that there is some language in Acree indicating that if there is sharply conflicting evidence about plaintiff's job performance, that it can possibly be taken into account. And district courts, and this goes back to what courts have repeated multiple times, is that district courts are given extremely broad discretion to determine remedies. So whereas in a case where the district court here had declared that reinstatement was the appropriate remedy, obviously defendants would have a huge hill to overcome to show that that was somehow an abuse of discretion. But that discretion is broad. And when the district court finds, based on evidence such as Randy Press's and others, that reinstatement is not appropriate, the district courts are given much leeway to make that kind of decision.
Let me ask about the evidence or the reasons for hostility of people at the university, at the college. It would be one thing if the hostility to her return was that after she was denied tenure, she murdered somebody or turned to bank robbery or something like that. And there are certainly cases saying that even though there's discrimination, you don't have to rehire somebody if they've engaged or you've discovered that they engaged in misconduct. But if the hostility is simply people who thought she didn't deserve tenure or people who are hostile for bigoted reasons, then it's hard to see why that should prevent her being reinstated. Do we know anything about the reasons given for being opposed to her reinstatement?
Yes, so we know some. In Dr. Press's affidavit, in his testimony, he spells out there was a variety of reasons. In his affidavit, he mentions lack of qualifications in his original vote. He mentions budgetary concerns, the fact that the position, and then we also know, based on plaintiff's own structuring of this case, that I apologize, Your Honor, my time has run out. I don't want to
go ahead and answer the question.
Okay. We also know, again, based on this case, plaintiff has never made any accusations that anybody, they can't possibly be bigoted because there's no accusations that anybody in the faculty, including Press, had anything to do with any of the incidents beforehand. So the fact that half the faculty oppose it is almost per se, you can't say that that was in any way relation to bigotry, because plaintiff has actually said repeatedly throughout this case and said, no, it's the faculty that was correct, not the administration. Thank you, Your Honor.
Any other questions from members of the panel?
Thank you. No.
Okay. Thank you, counsel. The case is submitted. Counsel are excused. And we'll go to our next case. This technology is incredible. We're actually ready there. Okay, good. We'll hear 19-6093, Hooks versus Atoki. Mr. Brookins?
Yes, Your Honor.
You may proceed.
Good morning, Your Honors. May it please the court. My name is Daniel Brookins, and I represent Mr. Hooks in today's appeal. Below, Mr. Hooks was not represented by counsel, and his claims were prematurely dismissed by the district court. In this appeal, we asked this court to correct those rulings and allow Mr. Hooks to return below and continue pursuing his meritorious claims. And specifically in today's argument, I'd like to address 3 points. First, the dismissal of the excessive force claims under Heck versus Humphrey. Second, the district court's decision to award summary judgment to defendant Atoki. And third, whether Kingsley versus Hendrickson changes the standard for pretrial detainee claims of deliberate indifference for failure to protect. And I'd like to begin with the first point, the Heck versus Humphrey issue. This was Roman numeral 1 in our briefing. Here, the district court held that these claims were Heck barred because Mr. Hooks alleged that he did not attack the officers and this would not sustain the elements of assault under Oklahoma law. This ruling was incorrect for 2 reasons. First, it improperly expanded Heck, and second, it failed to apply the liberal pleading standards that Mr. Hooks was owed as a pro se plaintiff.
I don't think you need to spend much time on the first issue. If there was excessive force that postdated that came after his being apprehended and arrested, then clearly heck would not apply. The question is whether a fair reading of the complaint would show that this claim was being made. That would have been the error by the district court. Can you focus on that point?
Sure, Your Honor. Especially under the liberal pleading standards, a reasonable reading of the complaint is that Mr. Hooks alleged that the excessive force came after he was subdued.
Could you read that?
Everything.
Could you read those pleading statements for us, please? Do you have them there?
Sure, I do. Let me just grab it real quick.
I don't want you to take your time. If you don't have it right there, just move on. We'll look for it. Proceed.
I do have it. It's here it is. It says, Chris Harding approached Ashina Yarborough's car with his gun drawn, ordering me to place my hands on the dash, which I did. Chris Harding opened my door and began removing me from the car. Once out of the car, Chris Harding began trying to take me to the police car without telling me why he was containing me. Chris Harding didn't try to place handcuffs on me, so I pulled away from him, like, what are you doing? Chris Harding and James Irby began wrestling with me. Chris Harding then pushed me between both cars and yelled for James Irby to taser me, causing me to drop to the ground and hit my head on the ground repeatedly and left me laying on my stomach, not moving at all. Chris Harding ordered James Irby to taser me again. After the second round of tasering, Chris Harding dropped to his knees and then placed me in a chokehold until Ashina started screaming.
Well, I remember that language in the pleadings, but that doesn't specifically say what he alleged as to when the arrest occurred. Now, I guess he says I alleged facts, and it's up to the court to decide when my freedom to leave was taken away from me. Is that your point? So we can then decide, okay, was he free to leave at the time he was tased the first time, or the second, or when he was taken down, or when he was met at the car, or when? So your point is simply that's up to us to decide when he was arrested.
If I understand Your Honor's question correctly, I think the answer is yes. And I think the answer is yes because Heck versus Humphrey requires a tightness of events for there to be the logical necessity leading to a contradiction between the Section 1983 claim and the conviction, which means that the district court's ruling here was really wrong for two reasons. The facts leading up to the excessive force don't really matter for purposes of Heck. And the reason there is because Mr. Hooks could be wrong about those facts and still win. So you wouldn't have the necessary contradiction. Multiple circuits have recognized this, and this circuit, in fact, recognized this in Martinez. In Martinez, the plaintiff was convicted for resisting arrest. He then brought a Section 1983 claim where he alleged excessive force. And in his complaint, he specifically alleged that he did not resist arrest. That directly contradicted his conviction. But this court held that the district court improperly applied Heck. And the reason is because he could have been wrong about that allegation and still won. In other words, even if he did resist arrest, even if he assaulted the officers in the process, the allegation there was that he rolled up his car window on the officer. That would have only entitled the officers to use reasonable force in response, not excessive force. So when we apply that here, we have a situation where even if Mr. Hooks is wrong about those so even if we take the district court's analysis as true, even if Mr. Hooks alleged that he didn't attack the officers, he could be wrong about that and still win. And under Martinez, that means that Heck doesn't apply.
Why don't you go to your other issues, Mr. Brookings?
Okay.
I think that was an invitation to go to them.
Sorry?
I understood that Judge Hartz was just inviting you to turn to those next two issues.
Yes, Your Honor. Sorry, I was just pulling up my notes.
Well,
I'd like to turn.
Can we skip quickly over two and get to your others because we're bound by strain, right?
So Strain resolved a very particular issue. Strain resolved deliberate indifference to medical needs. And this court, like most circuits in the country, have recognized different types of deliberate indifference claims. There's deliberate indifference to medical needs, deliberate indifference for failure to protect, failure to intervene. And just as Regalado refused to extend Kingsley to a context Kingsley didn't consider, this court should refuse to extend Regalado to a context it didn't consider. Regalado did not.
Let me interrupt. In Strain, we cite and rely on Farmer versus Brennan, a Supreme Court case in which it was deliberate indifference of prison officials to an incident where the plaintiff was beaten and raped by another inmate. So it looks to me like our analysis in Strain would apply more broadly than you're suggesting.
Your Honor, I would not read Strain quite so broadly. I think Strain was careful to limit both its holding and its reasoning to the medical deliberate indifference context. And I have some specific language I can point to. The court said, quote, "We hold that deliberate indifference to a pretrial detainee's serious medical needs includes both an objective and a subjective component," end quote. And its reasoning was similarly narrow. It said, quote, "Kingsley turned on considerations unique to excessive force claims, whether the use of force amounted to punishment. The deliberate indifference cause of action does not relate to punishment, but rather safeguards a pretrial detainee's access to adequate medical care." In other words, it's difficult to infer punitive intent in the medical context, but that's not the case in failure to protect claims. So we concede
the main thing that Heck was going on was that deliberate indifference doesn't involve the misconduct, the affirmative misconduct of the officers. It involves the officers' deliberate decision not to stop misconduct by others. And I think that the failure to call in adequate medical assistance, it's hard for me to see any difference between that and the failure to protect an inmate from violence by another prisoner.
Your Honor, I think you've got
the violation. The violence is not by the officer. The liability is because the officer fails to protect some wrongdoing by someone else. And isn't that the main commonality between Hecht and our case?
No, Your Honor. And I think this case illustrates why. Defendant Atoki allegedly was in the pod booth while Mr. Hooks had his face stomped on for a full minute. Those facts alone show that this is different from the medical context in Regalado, where he was just taking issue with the course of treatment. Here we're dealing with something where it's conceivable that a jail guard could punish an inmate through excessive force directly or indirectly, as the case here, possibly, by not doing anything when an inmate is getting attacked. And I think the en banc Ninth Circuit addressed this in Castro, and I'd like to just read a quick quote. They said excessive force applied directly by an individual jailer and force applied by a fellow inmate can cause the same injuries, both physical and constitutional. Jailers have a duty to protect pretrial detainees from violence at the hands of other inmates, just as they have a duty to use only appropriate force themselves. And they're getting at here, the excessive force and the failure to protect context are similar in that force is being dispensed whether or not it's the officer doing it or whether or not it's the officer allowing someone else to do it. And that's very different than the medical context that the court addressed in Strain. And if there are no other questions on that point, I'd like to briefly turn, Your Honor.
That's okay. You can use your time on your next issue.
I'd like to briefly address the district court's decision to grant summary judgment to defendant Atoki. The facts underlying this issue are truly gruesome. Mr. Hooks was attacked for a full minute by a rival gang. The jail personnel who reported noted in their reports just how bad it was. Deputy Lira said, "I observed a large pool of blood underneath Mr. Hooks' head. Inmate Hooks was unable to breathe due to the amount of blood coming from his mouth and nose." Captain Hardin said, "His face was covered in blood, a pool of blood on the floor just under his head. He was making noise as if he were struggling to breathe, and several officers were holding him to assist him in maintaining an open airway." And despite the fact that Mr. Hooks was beaten within an inch of his life, the district court still shut the courthouse doors on him. And to do so, it improperly drew two inferences in the move-in's favor. And as this panel well knows, on summary judgment, all reasonable inferences should have been drawn in Mr. Hooks's favor. Specifically, the district court held that the video showed that, quote, Mr. Atoki never approached the pod office window closely enough to see the attack. But the video doesn't show the whole pod. The video only shows a third to a half of the pod. And the testimony was an equipoise. The testimony of Mr. Hooks was that he saw Mr. Atoki in the pod, and the testimony of Mr. Atoki was that he wasn't in the pod.
So
that's a classic.
If we agree with you and we say that interpreting the facts in the light most favorable to your client, don't you still have a problem with causation and with whether a reasonable juror could find that 28 seconds is not a reasonable response time? I mean, the entire attack here took 28 seconds.
No, Your Honor. And I also would just slightly disagree with the characterization of the events. The attack started at 9:42:03 and ended at 9:42:45, which is about 43 seconds. And although those attacks were split up, that does have implications for the response time. Specifically, we know that the call for help came in at 9:42:36 and that the response came in at 9:42:55, which means that the response time is 19 seconds. And that also means that if the call for help had been placed at any time before 9:42:23, the second attack, which was arguably even more brutal than the first one, could have been prevented, and Mr. Hooks' injuries could have been mitigated.
So where is their allegation that Atoki knew about the danger, saw the risk, and made a decision, a subjective decision? I recognize this danger and I choose not to act.
Well, Your Honor, I think under the liberal pleading standard that Mr. Hooks was owed, those allegations are there. And I think the district court in its opinion even recognized that. Construing Mr. Hooks' allegations reasonably, the district court said that those theories were there. And I don't even think that the appellees have challenged that in this case. If there are no further questions.
I have a question.
Yes.
You said that there's evidence that Mr. Atoki was in the pod. What about whether he could have seen what happened? Because there was someone in the pod who came over within camera range and saw what happened. Is there any evidence that Mr. Atoki could have seen what happened if he was in the pod, but not within camera range? Because there's a difference between just hearing some commotion and seeing what's going on.
Well, I think this is why it's important to note that the video doesn't show the whole pod. We don't know what the other windows show. The record.
Well, isn't it pretty indicative if someone in the pod came to the part of the pod within camera range to see what was going on? Doesn't that suggest that you had to be in that position to see what was going on?
I don't believe so, Your Honor. I think that the video doesn't show the whole pod. And if I may I see that my time has run out. If I may just answer your question.
Yes, you may.
The video doesn't show the whole pod. And I think if we were to make the conclusion that you're implying here, which is that that Atoki could have only seen it if he walked to that spot, is to draw inferences in his favor. And I think the inference should be drawn in Mr. Hooks' favor, which is that you could see that spot from other places in the pod booth. We don't even have pictures showing what the whole pod booth looks like. And for that reason, we'd ask that you reverse the summary judgment decision as well as the other issues we've challenged in our brief. Thank you, Your Honor.
Thank you. Mr. Smith, are you leading off?
Yes, Your Honor. Good morning, Your Honors. May it please the court. My name is Carson Smith. I'm here representing Appellees Harding and Irby. As to the heck issue, this case spotlights the project of setting or buttressing the proper margins of liberal construction of a complaint subject to the Twombly analysis in a heck context. I would submit plaintiff's position and that advocated for today strays well beyond the margins, the proper margins of liberal construction, and it veers much more markedly into prohibited territory. I think that fact, that position of moving beyond liberal construction, is pointed up by the tension that we find with Twombly. I'll read a few common articulations of the Twombly standard and as against plaintiff's position. The reviewing court must accept the plaintiff's allegations as true and construe them and any reasonable inferences therefrom and the light most favorable to the plaintiff. Here, plaintiff's position implicitly asks the court to, well, let's take certain allegations as mistaken and kind of excise those from the analysis and take other allegations as true. It forces Twombly to be kind of a mixed bag and inverts the Twombly analysis.
Well, be specific about that, because Mr. Brookins read from the complaint, it sounded pretty reasonable to assume that he was subdued when some of the later force was used against him. So be specific.
Sure. I will, Your Honor. Thank you for that. So reading another articulation of Twombly, I think would dovetail into that.
I don't want you to read articulations of Twombly. I want you to be specific with respect to the allegations in the complaint.
Sure.
You just said that the allegation that force was used after he was subdued or that theory is contradicted by allegations in the complaint. I did not hear that from Mr. Brookings' reading of the complaint, so point that out. What I'm saying is it appeared to me, and I may have missed stuff, that the allegations were quite consistent with his being subdued. He's already been tased, he's down, he's hit his head.
And left me lying on my stomach, not moving at all. Yeah. And then second tasing.
Yeah.
Right. Your Honors, in that respect, if we home in on just those two sentences and we utterly eliminate the prior sentences, then it becomes a closer question. My point would be under Havens.
Be specific. What prior sentences are inconsistent with his having been subdued when the second taser shot?
Well, Your Honor, the sentences that precede that point, which would be 4 to 6 sentences. In fact, I counted 9 sentences that form the narrative of the version of events set forth by plaintiff. So plaintiff wants the court to delete those first 6 sentences, all of them, and focus on the 3 sentences that we're looking at now.
To the extent his claim is based on the first 6 sentences, it probably is inconsistent with Heck.
Correct, Your Honor.
Whether you can have 6 sentences that can't state a claim under Heck, and then have 3 sentences or 1 sentence that is consistent with the claim under Heck.
Your Honor, in looking at those few sentences, I think there might be an argument for that. My point is panning back. I think Twombly prohibits the kind of, Twombly is about framing the complaint, taking the allegations as true, and making sure there's enough factual meat to state a claim for relief that is plausible on its face. The kind of approach advocated for by plaintiff is, well, let's unframe the complaint and let's reach into the complaint and blot out certain sentences, and we'll elevate other sentences, and we'll minimize facts, and then we'll elevate facts. And I think that is contrary to both Twombly and to Havens in the way that a reasonable construction of the complaint means all the allegations of the complaint. It doesn't allow unframing the complaint and excising meat.
Isn't the law clear that you can have some part of the claim barred by Heck and another part not barred by Heck? I think that's all that's going on. You seem to think it's an all or none proposition. If it is an all or none proposition, you win, but it's not an all or none proposition.
No, I would agree that it's not an all or none proposition, Your Honor. However, to the extent that plaintiff relies on Martinez, I think it's indicative that Martinez was a pre-Twombly case. And I think it's indicative that both Havens and DeLon say there are allegations that plaintiff sets out that we can accept wholly as true without reaching into the complaint and reconstructing the complaint's allegations.
But if you look at those Havens and
let's go to other issues. Is that all right, Judge McHugh?
that's fine.
I will pass to Appellee, Mr. Young.
Good morning, Your Honors, and may it please the court. The sole issue on appeal with regard to my clients, I represent Armour and Dr. Childs. The sole issue is whether the court erred in applying the two-pronged deliberate indifference standard. And another way to say that is the sole issue on appeal regarding Armour and Dr. Childs is whether the 10th Circuit should adopt the Kingsley standard. As Judge McHugh has already acknowledged just a moment ago, the court is going to be bound by strain on this issue. It's already answered it decisively, which was decided since this case was briefed. For some background, in 2015, in Kingsley versus Hendrickson, the United States Supreme Court heard a claim brought by a pretrial detainee for excessive force brought pursuant to the 14th Amendment. The Kingsley court held that with regard to an excessive force claim, the plaintiff did not have to prove that the officer was subjectively aware that the use of force was unreasonable, and instead, an objectively unreasonable standard may be applied to an excessive force claim. Since Kingsley, several courts have heard similar arguments, and the Fourth Circuit declined to extend Kingsley to a claim for deliberate indifference to serious medical needs. The Third, Fifth, Eighth, and now the 10th Circuits have all outright rejected Kingsley's application to a claim for deliberate indifference to serious medical needs.
Apparently, a non-bank Ninth Circuit decision has gone the other way. Is that right?
Correct. I believe you're referring to Gordon Orange.
Well, it was a case cited by Mr. Brookins. Is there anything contrary you cited?
Yes, there is a split. The second, seventh, and ninth have each gone the other way. However, as I said, the 10th, 11th, 5th, 3rd, and 8th have each gone in favor of declining to extend Kingsley. So by my count, that's a 5-3 split in favor of the appellees in this case.
Do you have anything further?
Sorry, I was waiting for further questions. Yeah, I can keep going. In the 10th Circuit, in strain, the 10th Circuit relied on the actual language of Kingsley, which limits it to an excessive force claim. And additionally, the strain court relied on the very nature of deliberate indifference, as well as the definition of the word deliberate, which includes an inference that there must be some subjective element in the analysis. Additionally, I would point out that in appellant brief, he made a claim that even absent Kingsley, he should have an ongoing claim against the other appellees, whereas he did not include such a caveat regarding deliberate indifference to serious medical needs. And I point that out just to say that now that Kingsley has come along, now that strain has been ruled upon, it would appear to me that the appellant has conceded his claim in this case, at least against Dr. Childs and Armour, the healthcare providers. If there are no more questions, I can concede the rest of my time to co-counsel.
Okay, thank you. Any questions? Mr. Hagee?
Excuse me, may it please the court. My name is Rod Hagee. I represent the last appellee, Sergeant Atoki. It's unjust, frankly, that Sergeant Atoki was ever named, because he's the officer that ran to the rescue. And he was the officer that showed up on the scene of the gang fight and stopped it. He's the officer that immediately showed up and arrested the wrongdoers. And he did it in less than half a minute. The fact of the matter is that our pods on each floor of the cell contain a pod monitoring booth, and a non-contact officer is in that pod monitoring booth. The 4 camera videos that we provided to the district court clearly indicated that the only person in the pod was a Caucasian officer. Sergeant Atoki's African American, so there's no possible way the video gets it wrong as to who was on the floor.
Well, let me interrupt for just a minute. We have testimony from Mr. Hooks that he actually saw Officer Atoki in the pod. And doesn't that, you've got a conflict in the evidence. You've got Officer Atoki saying, I wasn't there. You've got Mr. Hooks saying, I saw you there. And you've got a video that doesn't show the entire pod. Wasn't the district court required to view the facts in the light most favorable to Mr. Hooks' testimony and say that Officer Atoki was in the pod?
I think the court did exactly that by comparing what Mr. Hooks said to the video, because the video unmistakably showed the Caucasian officer who saw the incident and called it in on the radio, which brought Mr. Atoki, Sergeant Atoki to the scene. And then Mr. Hooks admitted in his own briefing that it took 20 seconds to get through the security doors to the pod. And so that explains exactly why, from the time you see the Caucasian officer in the video, that you also then see Sergeant Atoki appearing on the video. The logbook produced by Mr. Hooks that he obtained in discovery showed that Mr. Atoki was not signed into the pod on that day. The testimony.
The question here is, we have a statement under oath, and at summary judgment, we've got to accept that unless there's just irrefutable evidence to the contrary.
Well,
you've got pretty strong evidence to the contrary. You've got to establish to us that it's irrefutable or that it's irrelevant in some way. When I say irrelevant in some way, that's why I asked if the evidence would show that if Atoki was not in camera range, he could not have seen the events on the floor. Is there any evidence one way or another on that?
There are 4
somebody in the pod who was not within view of the camera could have seen what was going on the floor with the prisoners, or could only have heard it.
There are 4 cameras. They show specifically who could see what.
4 cameras showing the pod? I thought there was part of the pod that was not within camera range.
One of the cameras does not show the entire pod. One of the cameras shows the other side of the pod. We have 4 camera views available on this video. And
so when you look at all the cameras together,
yes,
you can see the entire, I want to make sure I'm using the right terminology. The place where the guard was who saw what happened, that's called what?
The pod monitoring booth.
Okay, the booth. So if you look at all 4 cameras, you have a complete view of the booth?
Yes.
And the camera that would show the and those cameras were running the entire time?
Yes.
So we can see from those cameras everyone who was in the booth during this entire minute. Is that right?
Yes.
And the only one in there is clearly not a dark-skinned person. Is that right?
Right.
Boy, that wasn't clear to me. I thought there was a gap in the cameras.
No, sir. And all 4 views were.
How big is the booth? Could there be more than one person in that booth?
Physically, yes, there could be more than one person in the booth.
Is there any evidence here that was a possibility, or is that against the regs, or because he wasn't signed into the booth, you'll take the position that the record is just undisputed that he wasn't in the booth because he wasn't signed into it?
When combined with the cameras, yes.
But you're saying, regardless of whether he signed in, the cameras provide irrefutable evidence that there was only one person in the booth during this entire period, and that person could not have been Atoki because of skin color. Is that right?
And because Atoki appears on the video within 30 seconds of the other officer appearing in the pod, seeing the incident, because it takes 20 seconds to get through the pod security doors.
So if you're leaving the booth, what would you have to do to get from the booth to the floor?
You'd have to go out in the hall, come in through the security doors, which are very large, heavy steel doors that have to be opened by machine. No human can move them. It takes 20 seconds for them to cycle. It's a two-door
cycle.
The outer door opens, you enter the booth, you are acknowledged by the observers on the camera system. That door closes, the door to the cell pod opens. The fastest that can be done is 20 seconds.
It takes 20 seconds before there's a door open to get into the cell area.
Yes, from the hall.
So
the pod booth door is in the hall. There's no entrance in the cell pod area from the pod monitoring booth. It's a non-contact booth.
Okay. Thank you. You've already gone over, because we've asked questions, a couple minutes. Are there any other questions by members of the panel?
No.
Okay. Mr. Brookins, we'll give you 2 minutes then.
Thank you, Your Honor. I'd like to begin by picking up where Mr. Heggie left off. The cameras do not show the entire pod monitoring booth, and I would encourage the panel to go watch the video feeds, and you can see for yourself that you cannot see the entire booth. And also, Mr. Heggie is inserting facts that are not in the record. We don't have record facts about, there's no testimony elicited as to how long it would take to get from the booth to back into the pod. So all of that is irrelevant.
Is there evidence about how long it takes for the doors to cycle? I
don't believe so. I don't believe so, Your Honor. We also addressed this in our reply brief. They're trying to turn a statement that Mr. Hooks made in his brief into an admission, which is inappropriate for a number of reasons. It's also just irrelevant. And even if all of this is true, even if it does take 20 seconds to get from the booth into the pod, that doesn't mean anything. If we backtrack from 9:42:55, 20 seconds, that's 9:42:35. That means that Atoki could have been in the booth up until that point, which means he would have seen the entire first assault. So all of these facts just mean nothing. I'm not sure why we're spending time talking about them.
We're talking about deliberate indifference. You don't expect people to act instantaneously. They need to figure out what's going on, but okay. Go ahead.
I understand that the subjective component matters, but it matters based on the record before the district court, and these facts weren't in the record. And even if they do, they only established that Atoki wouldn't have been in the pod booth after 9:42:35, which would have been for the whole first assault. And I want to address one other point quickly. The argument by appellees regarding Twombly, I don't believe that was in their brief, and to the extent it wasn't, it would be waived.
Thank you, counsel. Case is submitted. Counsel are excused. Panel members, shall we take one more? Is that okay?
Fine.
Okay. We'll take one more case and then take a break after that. Our next case is Pope v. Lunday, 20-6003.
Maybe give him a little more light there.
Mr. Gillette or Gillette?
Miss Gillette.
Pardon? Oh, well, that's very unfortunate that you're that your names start with the same 4 letters. That's very hard on an old judge. I apologize. So, Miss, and your last name is pronounced how, please?
Gillette.
Miss Gillette. Okay, I apologize. Would you please proceed?
Yes, Your Honors. May it please the court. My name is Carmen Gillette, and I'm an attorney in Sarasota, Florida. I have the privilege of representing Kenneth Pope. I would also like to acknowledge my co-counsel, Laura McConnell Corbin, and Elizabeth Price in Oklahoma. Your Honors, we're here today on an appeal of a Hague abduction proceeding. We are asking the panel to reverse the district court's order that was rendered on December 23rd of 2019. We believe that the order is replete with errors of law, which culminated in a fundamental error of lack of due process and a failure to give Mr. Pope his day in court, for lack of a better phrase. And I would like to concentrate first on those errors of law. The first error of law that we believe should be reversed, Your Honors, is the district court's concluding that as a matter of law, an infant or a newborn child, as we have in the Pope case, could not.
Let me jump in right there. I'm not sure it's fair to characterize the district court as ruling that an infant cannot have a habitual residence. I think that if you fairly read the district court's opinion, it says, I've got some trouble wrapping my head around that, but even if a newborn can or must be assigned a place of habitual residence, these kids' habitual residence isn't Brazil. So one of the problems I have with the briefing is sort of this straw man that we're going to say the district court did something when you fairly read the opinion, it didn't do that. So I'd like you to deal with the district court's actual analysis of habitual place of residence, assuming that, yes, the district court made some stray comments about the concern about doing this for infants, but that's not ultimately what it did.
All right, Your Honor, I apologize. I read the order to say that as a matter of law, infants and newborns could not have a habitual residence, but even if they could, it would not be Brazil because the district court actually, had its own bright line presence test is how I read that it couldn't possibly be Brazil in that the children had never physically been present in Brazil. And we argued pre-Manaski, but certainly since the opinion articulated by Justice Ginsburg and Manaski, and actually some case law that has emanated recently, that physical presence is not a test for habitual residence for a newborn or otherwise. It may be one of the factors in the totality of the circumstances standard, but it certainly isn't a dispositive factor. And in this case, the court also, I think, conflated the issue of wrongful removal with wrongful retention. We specifically pled this case as a wrongful retention case at the moment of birth. The justice at the district court level seemed to focus on things that happened after the wrongful retention, things that happened subsequent to the birth of the twins in Oklahoma. But as you know, Your Honor, in a wrongful retention case, we don't look forward from the alleged date of retention. We can only look back, and looking back is actually symbolic looking back. And in this case, we would be asking to look back, symbolically at the moment of birth. So he clearly, I believe from the opinion, if he did not conclude as a matter of law that infants cannot have a habitual residence, he concluded that there must be a physical presence test applied. And if they fail the physical presence test, they cannot be held to have habitual residence in the proposed country.
Where do you read the language that you must have a physical? I mean, where do you read his language as saying that? Was he considered I thought he considered generally the entire situation, just like Monaskey instructed him to do.
Well, Monaskey instructs that the judge consider a totality of the circumstances standard, which requires an evidentiary hearing. And in this particular,
I don't see any authority that you have to have a hearing. You have to have a right to make a presentation, which occurred here.
well, we did make our presentation. We filed the petition, which was a sworn petition containing approximately 400 pieces of evidence. The response to the petition was unsworn and contained no evidence whatsoever. So I am not actually certain if this was treated as a sua sponte motion to dismiss the case or a sua sponte summary judgment in favor.
What the district court did is the district court assumed for purposes of decision that all of the allegations in your petition were true, correct?
The district court in the order says that's what he did, but in fact, that's not what he did, because he actually did make some findings of fact without taking the evidence. For instance, and Judge Ebell, I'll get back to your question about where it is in the order in just a moment. For instance, the court made findings that the parties were estranged. There's no evidence attached to that petition that the parties were estranged.
Well, isn't the lawsuit, the petition itself, and the fact that she was refusing to return to Brazil and refusing to bring the twins back, pretty good evidence that they're estranged?
Well, the question would be, when did that occur, though? And that's why we pled it as a wrongful retention at birth. There's nothing in this record at all that was in front of Judge Wyrick that would support that these parties were estranged. In fact, quite the contrary. The evidence was that they were communicating the entire time. She remained wearing her wedding ring. She continued participating in the renovations of the marital home in Brazil. She's referring to Mr. Pope as her husband. There was nothing in this particular record before the court. If you call it a record, it was not actually proffered as evidence. But there's nothing in this record that would support that she was not going to return those children to raise them in Brazil. And that's the critical moment in time. And that's why we pled it the way we did. There's nothing up until the moment of birth that would have led Mr. Pope to any other conclusion that this woman was returning with those children to raise them as they had planned.
How long was she? How long had she been out of Brazil before the birth?
She left Brazil on July 29th, and the birth of the twins was November 26th.
And when she left, was there any evidence in your affidavit material? Because the judge did say he was applying the evidence according to your statements. Was there anything in there about how long she represented she would be gone, or why she represented she would be gone when she first left?
Yes, sir. The evidence is that she purchased a round-trip ticket. She represented to Mr. Pope that she would be gone 3 to 4 weeks. She represented that she was attending a conference in Boston relating to her dental practice. She represented she was seeing her mother in Oklahoma and attending a bachelorette party on the West Coast, and would be returning in approximately 3 to 4 weeks, and again, had a round-trip ticket to do that. They had lunch on the day she departed for the United States at their favorite restaurant, said their pleasantries. She had a small suitcase, and off she went. And that is all in the record. And Judge, if I might ask you to look to page 6 of the district court's order, shortly above the last line, the very object of convention, et cetera, et cetera. And a child can hardly be returned to a place the child has never been. Thus, while the term habitual residence is not defined by the convention, the text does provide valuable context as the intended application of the term. And clearly,
so you take that statement, and I'm not saying it's right or wrong, but you take that statement as the reason for the decision.
I think the decision was based on several predicates, and one was that the suggestion that infants could not have a habitual residence. Second, moving to the next tier, even if they could, it could not possibly be in a place where they had not been physically present.
But let's go to that second tier, because judges often, and I read this, and I've read the ruling, as I'm sure my colleagues have. I read it as kind of an alternative presentation by the judge. There are several different lines of reasoning that got the judge to where he came out.
Right, but the case law and Minaski completely undermine the bright line presence test.
Right, so the first part might be wrong, but we've got that second alternative reading, which is putting aside the more unequivocal statements. Didn't the court consider all the evidence?
I don't know how it could, because we didn't have a trial.
Well, you had the opportunity to present any evidence to the court you wanted by your affidavit, and the court considered every single thing you presented and said he took the evidence as you presented it. He didn't even make his findings contrary to you. His finding was, I'm accepting everything that your client said.
Well, and he ruled as a matter of law, but he also made findings that do contradict Mr. Pope's petition and his position in this case. Again, there was no evidence that this relationship was estranged. And the critical issue in this particular case is the issue of the wrongful retention. When did Mrs. Lunday communicate to Mr. Pope that she did not intend to return the children to Brazil? That's the critical issue. And
let me ask you about inferences that might be drawn. If she says she's going to be gone 3 to 4 weeks and she stays significantly longer and does not contact him, isn't that a pretty good sign of something wrong with the relationship?
The answer to that question might be yes, but the convention doesn't permit the court to make such inferences. The convention is based on rigid constructs, which this case is classic convention case. The convention is meant to restrict the court from looking to a person's evolving nature, which can rupture unilaterally a situation relating to the custody of the child, or in this case, the children.
Well, evolving up to what point? If it's wrongful retention at the time of birth, by the time of birth, there's certainly evidence that the relationship was not good, that she didn't feel bound by any commitments made when she left Brazil.
The definition of
the reason for an evidentiary hearing is to get evidence. After you get evidence, you draw inferences. If you have any evidence that you're going to offer that the judge did not see, that's one thing. But you're complaining that with the evidence you presented, the judge drew inferences, and it's not clear what more you could have added as evidence at a hearing that would have changed the inferences the judge made from this.
Well, the inferences relating to the relationship would not be dispositive of when Ms. Lundy unequivocally communicated to Mr. Pope that she did not intend to return the children to Brazil for the purpose of raising them. The issue of whether perhaps she was unhappy in the marriage or became disenchanted with something along the way, or whether she chose to birth the children in Oklahoma as opposed to Brazil, is not dispositive of a wrongful retention case.
Nothing is dispositive. It's a holistic approach.
Correct, but it's the
You're
wrong.
saying that the judge couldn't even consider evidence? That doesn't ring true. Go ahead.
But the evidence in the petition is that at the first moment she communicated anything of this nature to Mr. Pope was at the moment of birth. Shortly after the moment of birth, when he traveled to Oklahoma and visited her in the hospital, and he asked her, when is she coming home? And she said, I'm not coming home. And that's the moment in time that the wrongful retention occurred. It didn't occur before that. It occurred at that moment when he unequivocally knew and there's witnesses that saw this. It's when it was unequivocally communicated to him that she had no intention of returning those children to Brazil to be raised, as had been the agreement between the married couple.
So that's the critical time, you say. And the question is, what was the infants, what were their habitual residences at that time?
At the moment of birth of the twins.
Wait, but you just said that the wrongful retention was when she told him, I'm not taking them back. So
correct.
So if that's the moment of wrongful retention, isn't that also the moment when you determine the infant's habitual residence?
Well, at this time, yes, and this occurred at the moment of birth.
So no, well, okay, I'm a little confused there. Go ahead. Well, your time is up. I'll give you 30 seconds to complete your thought.
Just that the moment of birth was the date of the alleged retention. And if you're looking at the habitual residence, you would be looking at the habitual residence of the children at the moment of the alleged retention, or symbolically moments before, during the birth.
So just to be clear, in response to Judge Hart's question, the violation, the wrongful retention, was not when she told her husband, I'm not coming back home. It was the instant that they were born. Is that your statement of the moment when the wrongful retention occurred?
No, the wrongful retention occurred when she unequivocally told Mr. Pope she would not return to Brazil, which was within hours of the birth of the twins.
Okay, all right, thank you.
Thank you, counsel. Mr. Dial, am I pronouncing your name correctly?
That's correct, Your Honor.
Go ahead.
May it please the court. My name is Matt Guile, and I represent Lauren Lunday in this matter. To briefly pick up where the court just left off on this issue of when the wrongful retention was alleged to have begun, with all respect to Ms. Gillette, that's the first time I've heard that it was sometime after the moment of birth. And I certainly don't have the record memorized, but my recollection of the record, the petition, and the brief still was that the wrongful retention began at the moment of the birth of both of the children.
Well, is your position that then the court can only look at the facts? That somehow Mononsky says that you can only look at the facts at the moment of retention? Or is this totality of the circumstances broader than that?
I do believe that it is much broader than that, Your Honor. In fact, I think the court did look at all of the circumstances in this case. And I understand my opposition's point is that you can only look back and not forward, but I think the court looked at all the facts in this case, and that's why the district court did not commit clear error when it determined that based upon the allegations made by Mr. Pope that he could not meet his burden to prove that children who were born in the United States to parents who were United States citizens and had never been to Brazil were not habitually resident in Brazil at the moment of their birth.
Mr. Guile, I don't know that it makes any difference in this case, but it might in precedent, depending on what is said in an opinion. But how long of a time gap was there between the moment of birth and the time that Mr. Pope was told that by Ms. Lundy that she was not going to return with the children?
The record does not reflect that, as my recollection. That based on the presentation of my opposing counsel, it sounds like the allegation is sometime that day. However, the record also reflects that the parties had had a conversation back in September in which he alleged that my client had become angry with him, shouted at him, said that he could no longer call her his wife. And so I think the court could infer from that there certainly his stated what Mr. Pope alleged was the purpose of the trip from Brazil to the United States was no longer the case.
Well, I'm not sure. The fact that she said you can't consider me your wife really is not dispositive if we accept as true the agreement that is pled or represented that the children will be raised in Brazil. But it probably doesn't matter, but it might in a future case, so that our articulation of it might matter. Do you believe that the wrongful retention was the moment the children were born, or the moment that she told Mr. Pope that she was not planning to bring the children back to Brazil?
I'm not sure, Your Honor. I think in this case, it would be the moment they were born, because the evidence was clear that she had made that decision long before the children were born. And so you
think that a wrongful retention is measured by when the party in possession of the children subjectively makes a decision not to return, not when the party in retention discloses that to the other side. Here, there's very little time difference, but just in terms of precedent, it could be very significant in future cases. So I just want to know which of those two times you believe is the critical point of wrongful retention.
Well, I believe, excuse me, Your Honor.
No, I mean, I guess the other thing is we could look at when she first communicated the wrongful retention to her husband, or when she first formed her own opinion not to return, or when there's some other event that happened. So I'm just looking for your guidance, more for future precedent than anything else, as to when that a moment of wrongful retention did. I don't want to take more of your time. Just state, and we'll worry about rationale, but just state the conclusion. What moment do you believe the wrongful retention occurred, or at least that we should consider as a matter of law to be the question of when the wrongful retention occurred, whether it was wrongful or not?
When the subjective intent occurred, Your Honor, which in this case would be at the earliest possible moment, would have been at the moment of the birth of the children.
Even if she had formed that opinion, that intent before the birth, maybe in labor, maybe she said, I'm not going to take these kids back. That you say it could not be before the children were in fact born.
I think that presents a difficult proposition based on the context of the convention applying to children.
I just trying to avoid mucking up the future law any more than we're probably going to do anyhow.
Understand, Your Honor.
Let me go ahead and answer, and then I had a factual question.
Our position would be that it would be when the subjective intent was formed. In this case, I think it presents a difficult proposition to say that the children were retained prior to their birth.
Okay, proceed.
Thank you. You said the record shows the conversation in September?
Yes, Your Honor.
Is that in her complaint?
It is not. I don't believe that specific allegation was made in the complaint. It was contained in the 400 plus pages of materials that were attached to the petition, which under 22 USC section 9005 are deemed self-authenticating and admissible.
Okay, so it was submitted by the plaintiff.
That's correct, Your Honor. It was attached to his petition.
I just wanted to see if there was some unfairness in the judge accepting that as true if the plaintiff was not accepting that fact. But that was actually in the materials she submitted.
It was, Your Honor. It was reflected in the Brazilian lawsuit regarding the first support during the pregnancy. Those were the allegations that was an ex parte order at that time that was it was reflected in those documents, Your Honor. To my knowledge,
it was ex parte because she was not involved in it.
That's correct. She was not served with that until after that point, Your Honor.
Well, is it appropriate for us to consider that then?
That was based upon the allegations that Mr. Pope made to the Brazilian court and then attached and would be incorporated by reference in his petition, Your Honor. So yes.
Would you think it's appropriate to apply that?
Yeah, I'm sorry, I got it backwards. Yes, I want to make sure it's fair to him to include that because he submitted. Okay.
Sorry, Judge Ebel, did you have a question? No.
Judge Hart's clarified that for me.
Okay. Your Honors, I believe that in this case, Mr. Pope is making an argument that habitual residence determination hangs on an actual agreement. Like the mother in Manaski, in that case, the mother was arguing that an actual agreement was required for the habitual residence to be deemed Italy. In this case, Mr. Pope is arguing that an agreement was required for it to be any place besides Brazil. He's urging an analysis that's so focused on the shared parental intent that it's difficult to imagine a case in which a habitual residence finding would be different than the shared parental intent, at least as he frames the issue. But the Supreme Court in Manaski held that the habitual residence determination does not hang upon the existence of an agreement. In fact, the court has to look at a totality of the circumstances, which I believe that the court did in this case. Looked at the facts and circumstances that the children were born in the United States to United States citizens, that they had never spent any time in Brazil, and that there was an alleged agreement when the children were 19 to 20 weeks in utero, but that there was never a time during the lifetime of the children in which they had come to that. And also
but that's not to say that the agreement is not, you're saying it's not determinative, but it certainly is relevant, isn't it?
Absolutely, Your Honor.
And it has to be considered. And that agreement was entered into when, I'm asking the question, this is a question, was that agreement entered into when Mr. Pope knew that Ms. Lunday was pregnant?
That is the allegation, Your Honor, yes.
Yeah, okay.
And so I think I absolutely agree that the agreement as alleged would be relevant. Where I disagree with my opposition is the weight that agreement should carry. The record also shows that my client left Brazil 4 months before the children were born, and that the parties never saw each other from July 29 until November 27. She returned back to her home in Oklahoma, which is where the parties met, where they both attended undergraduate and graduate school. And that's where my client had worked. In fact, the record also reflects that's the only place she was licensed to work as a maxillofacial and oral surgeon. And I think it's important to look at the starting point in this case, and that we look at the case law. A habitual residence finding in the absence of some level of physical presence is an exceedingly rare case. In fact, the case that was cited by the appellant is the Uzo case from the Northern District of Illinois. That case presents very unusual circumstances, which are different from the ones that exist in this case. In that one, you had two Nigerian nationals who were living in England, and they had an unusual agreement in which the parents agreed the mother would travel to the United States in order to bestow on children United States citizenship. And they actually followed through with that agreement with the older child. With respect to the second child, the mother in that case decided to stay in the United States, overstayed her tourist visa, and about a month after the child was born, the relationship between the parents deteriorated. Her asylum claim was ultimately denied, and the court found in that case, in the absence of physical presence from the younger child, that a habitual residence finding was appropriate. While that court looked in England, excuse me. While the court looked at the habitual residence through the lens of shared parental intent, I think that case presents very different circumstances from here, where we both have parents who have ties to the United States, unlike the parties in Brazil.
If you look at what the court relied on, it's that the babies were born in the United States to parents who were both United States citizens, and that since their birth, they hadn't spent any time in Brazil, and that since their birth, the parents hadn't made a decision as to where they would be raised. If that's all it takes, it doesn't encourage people to move to, if they have a disagreement with their spouse, move somewhere else and have the children there and say, I've now decided this is my habitual place of residence. I mean, it doesn't take much, does it, to create a habitual place of residence? Well, at least not have the habitual place of residence be where the marriage was consummated, and where the children were conceived.
I understand the court's point and would agree that in some cases that might be true. I don't believe that is this case because of the ties that both parties had to the United States. If the case, well, of course, every case is different from the other in the wake of Manaski, but I think each case is different. And if my client had traveled to some country in which neither party had any ties or any history or any ability to work in or a previous home, then the case would be different. And in that case, the result would probably be different as well.
So you believe we can look to the parents' historic ties to determine the child's habitual place of residence?
I believe that it makes a difference between just picking a random country that neither party had ever been to or had a tie to, and the case here where both parties were from the state of Oklahoma.
Well, and doesn't Manaski say when we have very young children, we do look to the caretaker's ties?
It does, Your Honor. That's exactly the language from Manaski. And in this case, I think it's the next point is that the court did not abuse its discretion in making this determination without holding a hearing. This court's precedent in West versus DeBrev answers that question about whether due process would be denied as a matter of law, that there's nothing in the convention or in the due process clause of the Fifth Amendment that would require a hearing, an evidentiary hearing in every case. The court has to balance the due process rights of the parties against the requirement that it act expeditiously in resolving these disputes. And in this case, Mr. Pope has not pointed to any additional evidence that he should have been able to present. He just says that from his brief, the statement was, Pope was and remains entitled to a hearing to present evidence concerning the last shared intent of the parties to establish the children's habitual residence, to which the district court would then apply appropriate convention law. So again, he's urging an analysis based on shared intent. For these reasons, we'd ask that the judgment of the district court be affirmed.
Thank you, counsel. Any further questions from the panel?
No.
Case is submitted. Counsel are excused, and we'll adjourn until 11:02. That's 10 minutes from now, and we'll reconvene at that time.
Court of Appeals for the 10th Circuit.
Thank you. We will turn to our fourth case of the morning, 20-6018, Frank versus Crawley Petroleum Corp. Mr. Sharp, are you ready to proceed?
I am, Your Honor. May it please the court. I represent appellants. We simply tried to dismiss this case with prejudice and found ourselves getting sanctioned. Rule 41A2 does not allow a restrictive condition on non-parties. Judgment just can't be binding non-parties. Both class members, future class members, as well as attorneys are non-parties. Both sides of this case advised Judge Wyrick that his purported order was not supported by the law, but he proceeded anyway. Dismissal with prejudice is pretty simple. There's a provided limited simple option of attorney's fees against the plaintiff under Rule 41A2, and that's set forth in Aerotech and only for exceptional circumstances. Those exceptional circumstances obviously were not present in this case, as Judge Wyrick found there was no vexatiousness in this case. And as this court has also found in the Vanguard versus Kieran case back in 2008, that filing a second similar lawsuit in a dismissal with prejudice context was not an exceptional condition warranting attorney's fees. This court has also found in the involuntary or in the dismissal without prejudice situation that filing a second suit, even if your intent is to try to obtain a tactical advantage, is not sufficient to constitute legal prejudice, invoking conditions to be placed on that plaintiff. Judge Wyrick sua sponte, and those are his words, not mine, he provided his own rewrite of Rule 41 and imposed conditions, not only on myself, but any future plaintiffs that I may represent against Crawley. This court rejected.
Counsel?
Yes.
A lot had happened in the case already, is that correct?
There had been briefing on class certification, but other than that, nothing else had happened. There was nothing set for trial, no motions for summary judgment.
Was there any discovery? Was there any discovery?
Absolutely. There's always discovery in these cases, as defendant always has all the evidence.
What did discovery concern? Did it concern the merits or just the propriety of certification?
It would concern both, usually, Your Honor, because there's overlap of merits and class certification, because you have to present a prima facie case on the merits to gain class certification. So class certification is a little bit of both. So there would have been some discovery that would have been useful as to the merits later on would not have been completed for class certification. But there was no motions for summary judgment or anything of that nature that this court held in the Church Mutual Insurance Company versus Salt Lake City Wesleyan Church, that there's no trial preparation just because you've engaged in some discovery and motion for summary judgment. That's not sufficient.
Excuse me. Try to keep your answers specific to the question.
Okay.
Now I've lost my train of thought because you went beyond.
I'm sorry, Your Honor.
No, that's okay. You are not challenging the second provision of the court's order saying that the discovery should not be repeated if plaintiff counsel brings another action. Is that correct?
That's correct, Your Honor, and that would be true because that discovery is available to the defendant and hopefully would be available to the plaintiff anyway, because discovery is not lost.
Let me ask you.
Go ahead. No, please.
Why do we have to decide this now? You haven't come forward with anything to suggest that you've got another class representative and that you're about to file an action and that you have some imminent injury that you're facing.
Well, we have present injury because we won't be able to represent Crawley royalty owners, not with this pending order sitting out there that says, one, you've got to come back in front of Judge Wyrick, who's also...
Do you have any, I mean, you say we won't be able to, I mean, have you tried? Have people turned you down? Have they gone to different lawyers? I mean, what is the evidence that you've put forward to show that you have standing now to bring this case?
Yes, the standing now would be that there is a sanction against my firm so that I can't proceed. There's also an order that says in the event that we do, the plaintiff would be subject to potentially $1 million in attorney's fees. That really closes the courthouse door and is present injury as to my firm seeking any kind of ability to go forward with a Crawley royalty owner. Of course, we couldn't present evidence before the order came down or before the order became final. We would only be able to submit that type of evidence that Your Honor is mentioning after this order came down. And yes, I have spoken with Crawley royalty owners, and they are not willing to go forward in this context. The reason I would speak with Crawley royalty owners is I already have substantial information about the wrongdoing that Crawley has been engaged in. Crawley is not concerned about the waste of their time or their factual discovery. They're concerned about being sued again literally by me, because I tend to sue some of the smaller defendants that other class action lawyers will not pursue. And so having them approach me and I have to advise them, I really can't represent you because you're taking on a significant risk of attorney's fees issues because of this order, because of this sanction. I suggest that they look elsewhere. They have been unable, at least as far as I know, to find any other counsel because no other cases have been filed against Crawley. To my knowledge, Crawley would probably know that better than I. With respect to...
Can I ask a different question? If we were to agree with you that these conditions are inappropriate, wouldn't the remedy be to remand, well, to reverse, I guess, the conditions, but then to remand for the court to reconsider whether the court even wants to accept the dismissal? Or to impose other conditions, or maybe to postpone the decision until the court rules on class action or other pending motions. So my question is, if we agree with you that this was wrong, what is our remedy and what do you think we are precluded from considering in a remedy?
Well, I don't know that the court is precluded necessarily from considering very many remedies. The one I would suggest is the one that you followed in the Olander case, which was simply to rule and not remand the case. In this case, it would be a dismissal with prejudice, ends the case. There's no further remand necessary. In the event that you were to remand this case, we would ask that you remand it to a case that hasn't already shown that he's going to be against the plaintiff and against, in particular, my firm as to how the outcome might come out. So either way, that would be options of the remedy that we would suggest you take.
And a third remedy would be to remand to this judge and say, you got it reasonably promptly on the request to dismiss, but if there's other pending motions that from a judicial efficiency point of view are ready to be disposed of, we're not going to preclude that. Would you challenge that as an inappropriate remand?
Well, after the length of time that has gone, this class certification briefing was fully briefed, I think, by 2017. We've had now 2 or 3 years that have gone by. Of course, the Chaparral, Naylor Farms versus Chaparral case that was handed down by this court in 2019 now shows the way for class certification. We had a chance to supplement that briefing somewhat, but we don't have the full updated discovery that would be necessary for a class certification ruling. There has been no ruling on class certification. We would need to get any additional leases, gas contracts, and plant statements that Crawley has. Now, granted, that would not be substantial because they've already produced most of that information and it doesn't change greatly over time, but there may be also nuances that we would want to explore with respect to, for instance, the Sunoco case that recently came out that allowed punitive damages under the Energy Litigation Reform Act. That case went to trial. Over $100 million was the verdict, and I think that case is now coming up to the 10th Circuit as well. So I think both sides would probably.
So would it be your position that if we remanded and we disagreed about whether Judge Wyrick was so biased and prejudiced that we shouldn't remand him, so if we disagree with that and we'll remand back to Wyrick, do you think that a remand could say, just take the case whole and should we say you need to rule on the motion to dismiss immediately before you do anything else? And if there is still record issues open, you can't pursue them to resolve other motions before you deal with a motion to dismiss? Or could we remand and say, if you're far down the road with these other motions, you can postpone ruling on the motion to dismiss until you take additional evidence and rule on other motions that have been pending for you for a long time?
Your Honor, I would suggest the former approach, to just simply rule on the motion to dismiss. There's been no evidence that the court or anyone else was far down the road on class certification, plus that briefing is getting somewhat stale. In addition, you have at this point a plaintiff, if you were going to go forward with class certification, he proffered some issues with respect to his health that was not, was offered in camera but was not accepted. So as a result, he may not be an appropriate class representative to go forward on behalf of the class for a class action that may go for another 2 or 3 years.
But you can substitute a new class representative in without dismissing the case.
You certainly could, assuming you had a class representative that was willing to go forward under all of those circumstances. Royalty owners generally are in the 70 to 80 years old range. They're obviously going to be wanting to know what's the prospect, whether you're going to be certified as a class and get through to the merits. And I should address the question. I'm not suggesting that Judge Wyrick is biased. I'm suggesting this may indicate an appearance of impropriety, that you should move the case on to someone else. I think it's a much harder burden to prove bias, and the fact that Senator Whitehouse may have suggested that, and that may be in the public domain, does not necessarily make it true. With respect to the issues of legal prejudice, or as the court has said, substantial or clear legal prejudice, this court could look at the 4 Olander factors. Judge Wyrick certainly did. And I will address those in turn, although it's not crystal clear to me that they apply with respect to a dismissal with prejudice. The first one being Crawley's effort and expense preparing for trial, as I indicated, and maybe overstayed my welcome on that question. This court has ruled previously in the Church Mutual Insurance case that trial preparation of discovery and even a motion for summary judgment is not sufficient to trigger clear legal prejudice. And really, Crawley here is not concerned about that it's got effort and expense in preparing for the trial or even preparing for class certification. What it's really concerned is that will not be wasted time and that there will actually be another case filed. The fact discovery, that's not going to be wasted. It's stored electronically and can be reproduced at the push of a button. Legal briefings the same way. What Crawley fears is the merits. There's been more than $1 billion recovered by royalty owners in Oklahoma alone. So these cases are not frivolous. These are not a nuisance value settlement type cases. They are real cases. Plaintiff's lack of diligence in this case, there's been no evidence of that, really not even alleged. With respect to the insufficient explanation for dismissing, while legally the issue is whether the dismissal explanation legally prejudices Crawley, certainly that doesn't happen here. As I indicated, there was issues with respect to health, which is usually something with respect to the court is not required to be publicly stated. Judge Wyrick, instead of going down that path, decided to jump the tracks and go to this issue on forum shopping. And I do want to address this briefly because I think his definition is quite frankly wrong legally. I think the 10th Circuit in Predator International versus Game-O Outdoor established that improper forum shopping, as opposed to proper forum selection, improper forum shopping is when, quote, a party attempts to avail itself of a forum it perceives to be more favorable without any legal or factual basis for doing so, thereby causing unnecessary delay or needlessly increasing the cost of litigation, unquote. That case, I think, sets forth the proper standard for what is improper forum shopping versus forum selection. Forum selection was used by both parties.
Counsel, wrap this up. Your time has expired.
I'm sorry, Your Honor. I will wrap up and ask that the court consider the remedy in Olander and simply dismiss this case with prejudice. Thank you, Your Honor.
Thank you, counsel. Mr. Stein.
Thank you, Your Honor. May it please the court, my name is Patrick Stein and I represent defendant appellee Crawley Petroleum. We'll be presenting argument on its behalf this morning. Nobody has presently been hurt by the judgment below. Fundamental precept of appellate jurisdiction is that in order to appeal, the party appealing must have been directly aggrieved by that judgment. Mr. Frank.
I don't know how you can say that nobody was hurt. If you take an attorney and say that attorney, if that attorney is going to represent certain clients, has got a lot of baggage that goes with it, and that baggage is already declared and already decided, there's nothing hypothetical or future about it, that baggage has been put on that attorney's shoulders. And I don't know how you could say, I'm hurt if I have to travel my professional career with an extra load that you have put on my shoulders right now.
Yes, Your Honor. So let me address that in kind of two phases. One, I want to start with this idea that what the conditions that Judge Weyrich imposed were sanctions. They were not. A sanction is fairly well stated in this court's Butler opinion that plaintiff cites. Got to have a finding of misconduct. So any order finding misconduct is an appealable sanction. That hasn't happened here. And so without the sanction hook to rely upon, we're back to when are Rule 41A conditions of dismissal appealable? And courts have drawn lines between what's called legal prejudice and practical prejudice. And I want to juxtapose the Versa Products case from the 11th Circuit with the LeCompte case from the 5th Circuit talking about these points, because the conditions on counsel haven't come to fruition yet, right? The attorney's fee one in particular just tells us that we have the right to file a motion under Rule 41D for costs and attorney's fees. Crawley hasn't been awarded any attorney's fees at present.
I think you can put that aside. You can put that and the continued discovery aside, because the rules deal with those. But just deal with the restriction on the attorney that if the attorney is going to file, the attorney has to file in this particular district and before Judge Weyrich.
Right. I'll point the court to the Versa Products case on the venue restriction. Okay. In that case, there were two conditions that were imposed by the district court. One was attorney's fees. One was a venue restriction that said any refiling will be in the Northern District of Georgia. The 11th Circuit in that case dismissed the case and said that venue restriction just preserved the status quo, and requiring a case that was properly in the Northern District of Georgia to be refiled in the Northern District of Georgia was not the kind of legal prejudice that gave the party a right to appeal right then. So too here. The case was originally and properly removed in October of 2014 to the Western District of Oklahoma, and it was litigated there for 4.5 years before a judicial assignment caused Frank's counsel to, in the words of the appellate brief, in light of that assignment, they sought dismissal. Frank's counsel, after subjecting Crawley to substantial expense, wants to run out of court and go bring another lawsuit in another forum. Now, I agree with Mr. Sharp that if that subsequent lawsuit, if there's no basis for subject matter jurisdiction in that subsequent lawsuit, then Judge Weyrich's order can't supply subject matter jurisdiction for that subsequent lawsuit. But Judge Weyrich's order, the district court's order, limited his conditions to lawsuits that were substantially same as the Duncan Frank lawsuit that was brought. That would include lawsuits within federal court's CAFA subject matter jurisdiction. And so, yes, there is a restriction that if Mr. Sharp and his colleagues are going to file substantially similar class action against Crawley, that be done in the Western District of Oklahoma. But that is not the type of legal prejudice that gives rise to an appealable order.
You don't think that legally that is going to deter his ability, his free ability to get and accept clients?
Again, I would point the court back to the distinction between practical prejudice and legal prejudice. I mean, frankly, we have no idea how Judge Wyrick is going to rule on any of these issues. He's a newly appointed judge. He's a blank slate.
Well, he's a blank slate, but there's been a history of acrimony there, apparently.
I think it's anticipated more than real, Your Honor. But in any event, having to file a case in the Western District of Oklahoma, where we have litigated this one for 4.5 years, that's not a legal prejudice. And if the concern is that the plaintiff is not going to get a fair shake in some other court, or isn't going to get a fair shake in the Western District, I just don't think that there's anything to support that, Your Honor.
Well, let me get to the heart of the order. What was the purpose of the order? Why impose any restrictions at all on the right of Mr. Frank to have, I'll say right of Mr. Frank to dismiss his case with prejudice? What harm to Crawley, what unfair thing happening to Crawley requires these restrictions?
Sure, Judge. So 2 things that I think are reflected by the district court's order and supported by the record. One, it's the duplicative litigation expense that's going to come in the next case to get the anticipated next case to the same position this one was in.
Okay, well, but what if this was litigated and the judge said, I'm not certifying a class? So then Mr. Sharp can get another client and bring another class action case, even if the judge ruled that way. Do you agree?
I do agree that he can do it.
So what's wrong? So where's any harm to you from the dismissal with prejudice? Even if this went on to class certification and Mr. Sharp lost, he could still bring another case.
He could bring another case, Your Honor. And I'm going to reference the Smith versus Beyer case from the U.S. Supreme Court that held that there's no issue preclusion on a subsequent class rep as a matter of federal law. But I want to go further down that of Justice Kagan's opinion for the court in there, where she didn't say that this issue isn't real. She said principles of comity, we would expect federal district courts to apply principles of comity in that subsequent case so that we are not continually relitigating the certification issue. So yes, he could file the case, and yes, issue preclusion if federal law is the test doesn't apply, but that doesn't mean that we're still serially relitigating the certification issue in every case.
Well, it doesn't. No, it does mean you're serially relitigating. It's just that the winner, I guess you, would want the later judge to agree with the first judge's ruling. But district judges in the same division disagree with one another. There's no legal, you haven't suffered any legal injury by having this proceed. So I don't see any need, I don't see what the purpose of these restrictions are. You're not worse off than if you had won on certification.
I disagree with that, Your Honor. We would be worse off. And
how would you be worse off than if you had proceeded to litigate certification and you won? You would be worse off because the Judge Wyrick's decision might be persuasive to another judge.
Yeah, and to the point
where anything else?
to the point that we wouldn't have to go through this rigmarole again, where we wouldn't have.
What wouldn't you have to go through?
I file an early motion to dismiss based on the prior dismissal. And of course, it's kind of speculative to depend on what I think. Let me back up. I think the principles of comity issue could be raised before the motion for class certification. I think it could be raised at effectively a 12B motion context.
And so say to the judge that you should follow what Judge Ryrick did just as a matter of comedy.
Yes, that these issues have already been litigated.
I don't think that's a legal right. That strikes me as not very substantial, given how often, at least it seems to me, district judges in the same district disagree on important matters all the time. I see my colleague smiling. Maybe I'm wrong about this, but
I've observed that as well.
Yes, yeah.
I take the court's comment, and I want to move on to the second thing I want to focus on.
Well, this sounds to me like it's dispositive. Maybe you're still responding to why you're worse off than you would be if this proceeded to a decision. Go ahead.
So I think the second component of this is we're 4.5 years in, and the decision to leave and go refile is purely driven by trying to select a more favorable judge. And that is, I mean, I didn't get to pick the first judge that got assigned to the case. I didn't get to pick the second one. I didn't get to pick the third one. I didn't get to pick this panel.
But that's implicit in the Supreme Court's ruling that if you lose on certification, you can start all over again with another plaintiff, go to another court, go to another district, perhaps. That's just, that may be problematic, but it's the law, and it's not clear how you're worse off. In fact, you're better off because there might be statute of limitations defenses that arise. The longer the first case is taken, the more likely you've got statute of limitations problems if you file a new case.
I disagree with the court's characterization that we're not worse off, or that we are worse off.
You're worse off, but that's a consequence of what the law is. That's a consequence of the fact that a decision denying class certification doesn't bind any member of the class who isn't a named party. That may be unfair, but that's the Supreme Court's decision. And given that, I just don't see any need for you to be protected by this order. I'm repeating myself.
So I want to point the court to, this isn't on all fours, but I want to point the court to the Brown versus Bakke case out of this court, where there were still, the district court there imposed conditions on dismissal similar to two of the conditions here, the fees issue and the discovery carrying over in a subsequently filed case. Even though the court permitted dismissal there, the court still awarded attorney's fees to compensate for the duplicative effort. And so it's this duplicative effort that's not occasioned by a subsequent filing, but we would have a decision, and we're going to have to redo the discovery we did in this case and do additional discovery in the next case. And that,
why are you going to have to redo it? I thought the order does. They're not challenging the part of the order saying the discovery should be reused.
Yeah, I was imprecise, Your Honor. The discovery we've done, we can reproduce in terms of document production. What we will have to do, though, is retool all of our expert reports. We'll have to retool all of our legal arguments to address the new named plaintiff. And that's not just a matter of pushing a button, as Mr. Sharp said. That's significant merits-based work that we will have to do.
Well, when you say to address the new named plaintiffs, is that any different from whenever may substitute plaintiffs in the same proceeding? Is this discovery an argument related to the adequacy of representation of the new plaintiff, or is there something more going on here?
Part of it's related to the adequacy of representation of the new plaintiff, but I also tailor the arguments about commonality and typicality around the named plaintiff's claim. So I'm closing in here, and I want to come back to this fundamental precept that nothing presently has happened to Mr. Sharp in his law firm. He hasn't been sanctioned, and the venue restriction that is imposed is not the type of thing that gives rise to legal prejudice, giving him a right to appeal. And there's been no award of attorney's fees. And so we ask that the court dismiss this appeal for lack of jurisdiction or alternatively affirm. Thank you.
Thank you, counsel. Any further questions from the panel?
No.
Thank you. Case is submitted and counsel are excused. We'll turn to our final case of the day, which is Schell versus Oklahoma Supreme Court Justices, 20-6044.
Good morning, Your Honor. If you're ready for me to proceed.
I just had to pick up some stuff. So, Mr. Dick, you're going to argue this? Go ahead.
Yes, Your Honor. Good morning. Anthony Dick for Plaintiff Appellant Mark Schell. I'm going to do my best to reserve 5 minutes of rebuttal time, excuse me if I may. So I'll do my best to stop talking after 10 minutes have elapsed.
No one has succeeded yet. Well, I guess one attorney has succeeded today.
Hope springs eternal. It is a fundamental principle of the First Amendment that the government cannot force individuals generally to join and give financial support to an organization that engages in political and ideological advocacy that they oppose. Defendants in this case do not really dispute this general First Amendment rule. Instead, they rely entirely on the argument that the Supreme Court's decision in Keller somehow creates an exception to the First Amendment rule and authorizes compulsory membership and subsidies for bar associations. But I submit that argument is based on just a clear misunderstanding of Keller and what Keller's actual holding was, as opposed to the mere dicta of Keller. So to understand what the actual
Let me pause just a second on that. We have been instructed that lower courts have to accept and give weight to dicta as well as holdings by the Supreme Court. Isn't that correct?
That's correct, Your Honor. But as I explained in my brief, there is an exception for when the dicta of the Supreme Court conflicts with the Supreme Court's actual holdings and when the dicta of the Supreme Court has been eroded by subsequent holdings of the Supreme Court. So in this case, we think that it's quite clear if you read Keller that the actual holding of the case is that mandatory bar dues and membership are subject to the same constitutional rule under the First Amendment that applies to mandatory public sector union dues. And so at the time when Keller was decided, of course, that was a different constitutional rule than exists now. But the reason we think that the clear holding of Keller is this equation between bar associations and public sector union dues is because that's what was necessary to overturn the decision that Keller was actually reviewing in that case. So you have to look at what the posture was as the case came to the Supreme Court in Keller. And the posture of the case was that the California Supreme Court had rejected a First Amendment challenge, just categorically rejected a First Amendment challenge to mandatory bar dues. And what was the ground for rejecting that challenge? The California Supreme Court said bar associations are not private entities, they're government agencies. So they're categorically exempt from First Amendment scrutiny. So the people, the First Amendment plaintiffs went up to the United States Supreme Court and asked the court to overturn the ruling that bar associations are state agencies exempt from First Amendment scrutiny. So the U.S. Supreme Court was confronted with the question, should we overturn the ruling that bar associations are exempt from First Amendment scrutiny because they are government agencies? And who won that case? The people who won that case were the First Amendment plaintiffs. They convinced the U.S. Supreme Court to overturn the California Supreme Court's holding that bar associations are categorically exempt from First Amendment scrutiny when they collect mandatory dues. They said that's not true. They're not exempt from scrutiny. So that is the disposition of the case. That's the core of the holding, to reverse what the California Supreme Court said. It's untrue that they're exempt from First Amendment scrutiny. And then what is the other component of the holding? It was the reasoning necessary to that result. And the reasoning necessary to the result was they're not government agencies. They're analogous to public sector unions that collect compulsory bar dues. So that was the holding in the sense of that's the reasoning, and that is the result to reverse the lower court's decision exempting them from First Amendment scrutiny. And they said they're analogous, so they have to be subject to the same constitutional rule that public sector unions are subject to. So we think that's the holding. And then there was, to be sure, some subsequent dicta where they said, and here's how we think that same constitutional rule would apply based on the case of Abood, which was the case that then supplied the constitutional rule for public sector unions. And so everything the court went on to say about how it thought the Abood rule would apply to the case of mandatory bar association dues was dicta, because it was not necessary to the disposition of the case, which was to overturn the California Supreme Court's holding that bar associations are categorically exempt from First Amendment scrutiny. So we think that just leads very clearly to the place that the holding is apply the same constitutional rule that applies to public sector unions. After Janus, that constitutional rule is exacting scrutiny, and the state doesn't even try to explain how it could possibly satisfy that constitutional rule.
Do you find it surprising that Janus didn't indicate that it was overruling Keller?
No, Your Honor, we don't think it did overrule Keller, and we don't think it had any reason to address bar dues because none of the parties there made any arguments about bar dues. But again, this is an essential point of our argument. We're not asking anything about overruling Keller. We don't think Janus overruled Keller at all, because we think all Keller held is that bar associations are subject to First Amendment scrutiny, and the proper constitutional rule is the same one that applies to public sector union dues. So it didn't get into how that standard applies in the holding. It didn't say anything about what courts should do when applying the constitutional rule. It didn't even say what the constitutional rule is. It just said it has to be the same constitutional rule. So we're asking you to apply the holding of Keller, which is to say that you must apply the same constitutional rule that applies to public sector union dues. After Janus, it's quite clear and binding on this court that the constitutional rule is exacting scrutiny. That's not necessarily fatal if the government could show that it had a real need to serve a compelling interest by forcing people to join a bar association and forcing them to pay bar dues to subsidize political and ideological speech. If they could make that showing, then they could maybe justify what they're doing, but they can't make that showing.
Let me ask you, there is a very strong interest in having the bar educated and having disciplinary actions taken against the bar, against members of the bar who violate it. And part of the principal reason for requiring attorneys to join a bar association is to pay for these activities, that rather than imposing that on the public at large, those who benefit from being members of the bar most should pay that. Do you have any concern if, say, you didn't have to belong to the bar association, but you had to pay a fee every year, which goes to those activities to send out a bar bulletin with the decisions of the court, give information about CLE programs, maybe develop CLE programs, things like that. Not unlike the dues that you pay to the 10th Circuit as a member of the 10th Circuit bar. Would you have any problem with that sort of arrangement?
Well, Your Honor, we think that actually illustrates the point that there is a substantially less restrictive way the state could achieve those goals here. I mean, we think there are 20 other states that regulate the profession and serve those goals without requiring mandatory bar membership and without requiring mandatory bar dues. So we think if you had a licensing fee, for example, you want to be licensed to practice law in the state, pay a licensing fee, and the regulatory agency can use that fee to cover the costs of its regulatory functions. There's no need to make us join a private organization, pay dues to a private organization that engages in political and ideological advocacy. So yes, we think that it probably would be permissible to require a licensure fee for a regulatory body to do its work. But that proves the point. Why are they making us join and pay money to an organization that engages in political and ideological advocacy and talks about Al Gore's environmentalism, talks about, disparaging wealthy conservative libertarians, whatever that means, talks about oil and gas regulation. There's no need. It's an egregious First Amendment violation and a completely unnecessary.
So, but under the arrangements in Oklahoma, that's all you actually have to pay for with your dues. You don't have to pay for any of the ideological activity. And so your problem is you don't like being considered a member of this organization. Is that what it boils down to?
No, that's incorrect, Your Honor, because what the Bar Association considers germane to its mission actually does include a substantial amount of political and ideological advocacy. I mean, if you look at what the things they think are germane, what they can compel people to pay for, it includes things like talking about judicial selection, tort reform, publishing a bar journal that talks about Al Gore and his environmental policies.
Well, if that's offensive to the First Amendment, then you can challenge having to pay those dues. Let's say you win all your challenges so that you don't have to pay for that stuff. You think arguing for retention elections instead of partisan elections is inappropriate, that's ideological, and you shouldn't have to pay. If you prevail on that, is it still your position that you shouldn't have to be a member, that being a member is offensive?
Yes, Your Honor. So two quick things about that. Number one, that was still the case in Janus. They said you can't force people to pay and then seek a refund and go through, a lengthy and expensive arbitration process to get your money back. You need affirmative consent before they can make you pay money to them. If they say they're going to engage in this type of political and ideological advocacy, you need to get affirmative consent beforehand. You can't make them go through this refund process. But on the second point, yes, we do think that forcing people to join is a separate injury. We think that the Keller case clearly reserved this question when it said, there's a separate question about whether membership, forcing you to join an organization that engages in non-germane political and ideological advocacy would be permissible. And we think that's clearly the case here. So we think this falls into that question of compulsory membership as a distinct injury that was reserved in Keller. I do see I'm at 4 minutes, so I would like to reserve time for rebuttal unless there are further.
I just want to ask a question factually about this case.
Yes, sir.
Apart from the law, you're saying there's this offensive material that is non-relevant, not germane, but you have I believe it's a 2-year statute of limitations, and all of the stuff that you claim to be, about Al Gore and about various policy issues precede that 2-year statute of limitations, so that the only statements that you cite about what the Oklahoma Bar Journal reported in the 2-year time frame appear to me very germane to the practice of the law. So I don't know. I mean, this case has some very difficult legal issues in it, but it seems to me this particular case that you brought may suffer a real problem because on the record, we can only consider a few of the Oklahoma Bar State articles, and they all clearly appear to me to be germane to the practice of law.
Well, no.
I'd like to get your comment on that.
Yes, Your Honor. We're not seeking retrospective relief, of course, in the way that we would need to do if we were attacking previous expenditures for being unconstitutional. We're merely saying we're seeking a prospective injunction to prevent the bar from engaging in this type of unconstitutional activity.
But you don't get a prospective injunction without proof of a violation. And we look for proof of violation to conduct within an appropriate statute of limitations period.
Your Honor, the proof of the violation is what the bar's policies are and what they allow the bar to do. And it's quite good
within
evidence.
the statute of limitations period. And your only proof, I mean, the Bar Association's policies can change. They do obviously change. So your proof has to be within the statute limitations. What are their policies? And the policies of the articles, as far as I can tell, are all quite germane and non-offensive to legal practice in this particular case.
If you look at the policies that continue to exist, including the new policy, they authorize the bar to engage in, and they don't disavow this. I think they're quite willing to concede that they do have authority to publish the bar journal, to speak out on issues that affect, and they will say this is permissibly germane.
I don't want anything about what they would say or wouldn't say. All I can deal with is the record, what is on the record. And the record I don't see the Bar Association on this record saying we can make statements about who ought to be the next president.
Well, you can look at the.
I just simply see statements allege, here are things that were published that were offensive. That's all I see. And those things, some of them were outside the statute of limitations period.
Your Honor, if you look at, for example, just the bylaws of the OBA, as we allege in our complaint, it says that they have the authority to make recommendations on all kinds of proposals about court organization, selection. They have the ability
legal related court, and
right, which is again
legally related.
Again, but that's precisely the type of thing that, even if it is legally related, would be unconstitutional still to force us to support under the rule of Janus, under the same constitutional rule.
Yeah, if you're arguing that Janus goes that far, I think it's just plain contrary to Lathrop and Kelly. If you're trying to say that Janus abrogates the ability for the bar to speak about legally related subjects, then I think that's a very hard argument to make.
I appreciate that, Your Honor. Two quick points. So number one, again, we're not saying that it overturns and prevents the bar from doing that. We're just saying it prevents the bar from forcing us to pay for it, which is a very important distinction. And two, I think if you look at Article 8, Section 4 of the OBA's bylaws, they provide that the OBA may endorse any proposal for the improvement of the law, procedural or substantive, with no restriction on subject matter. So I think it's quite.
But it's all preceded by improvements of the law.
But improvements of the law can be, we think that the law should make penalties less strict for crimes, right? I mean, that's
when you get a case where that's violated, you bring it, but you got to bring it within 2 years.
Well, no, Your Honor, because we're seeking prospective relief against the ability of bar has to.
I know, but prospective relief does not eliminate your need to prove violations within a time that we can legally take cognizance of them.
But Your Honor, the violation is the taking of the money, which can be used for the purposes spelled out in the bar's documents. And so we think that because those purposes clearly authorize those uses, that it is unconstitutional and those violations have occurred. And
but you're hanging on the statement about related to the law. And you're saying that is such a broad statement that by itself is unconstitutional.
No, Your Honor, we think that is a fortiori, but we also think that even if there is something that's germane and related to the law, under the rule of Janus, which now applies in light of the holding of Keller, that the same constitutional rule has to apply to public sector unions and bar associations, we think even forcing people to support quote unquote germane speech is subject to exacting scrutiny, which cannot be survived because there are many ways that the bar association's regulatory functions could be performed without requiring us to subsidize that type of germane.
And your exacting scrutiny you get to because of the reference to a case that you believe Janus later overturned.
No, because we think that it didn't overturn it. We think that Keller said you apply the same constitutional rule. So we're not saying to overturn that holding. We're saying follow that holding. The same constitutional rule is what Janus requires, and that is exacting scrutiny. So we're saying follow the holding of Keller, apply the same constitutional rule, apply exacting scrutiny to any requirement that we pay dues for an organization engaging in political ideological advocacy. Even if it is germane, that still is subject to exacting scrutiny under the Janus rule, which is what the holding of Keller requires. It's not overturning Keller, it's just applying that holding of Keller, which says apply the same constitutional rule.
Judge McHugh?
I'm fine.
No, I don't. No. Ask your questions.
My question was whether you can point to any practice in this case that exceeds the practices by the bar upheld in Lathrop.
Well, of course, Lathrop did not uphold any particular practices because the court said it wasn't clear enough on the record there what practices were engaged in by the bar. So, it expressly declined to decide. As Keller explained, Lathrop did not decide the question of whether you can, file a successful First Amendment challenge to a bar association that is using your fees for political and ideological advocacy you're opposed to. So that's the issue that was left open in Lathrop. I think there are things here that
But they upheld the mandatory bar dues, right?
They said mandatory bar dues could be permissible in a bar association just on their face if it were just engaged in regulating the bar and not doing any political and ideological advocacy. So that's, I think, the bare minimum that they were talking about. They weren't talking about the issue presented here of political and ideological advocacy, right?
All of those issues were raised, weren't they?
They were raised, but the court didn't address them because it found that the record wasn't clear enough, and there had been, a judicial notice of a bunch of things. So it wasn't like the present case where we were on a motion to dismiss. So if there are questions about what the bar is doing and what kind of factual issues the court thinks should be resolved, that would be appropriate for the district court to look at. But we think our allegations should be taken as true, that there is non-germane speech that's being funded and being paid for by the bar. Of course, they won't show us everything that they're doing. So we think it would be quite unfair on a motion to dismiss not to take our allegations as true and not at least to allow us to have discovery on what the bar is using our money for.
I'd like to pursue this issue of the offense that might be taken from being a member of an organization that takes positions. And I'd like to read you a passage from Justice Harlan's concurrence in Lathrop and ask you to respond to it.
Sure.
This is on page 860 of the opinion. He says, I do not think a subsequent decision by the representatives of the majority of the bar members to devote some part of the organization's funds to the furtherance of a legislative proposal so identifies the individual payer of dues with the belief expressed that we are in the Barnett realm. I assume that's the Pledge of Allegiance case he's referring to.
Right.
That we are in the Barnett realm of, quote, asserted power to force an American citizen publicly to profess any statement of belief or to engage in any ceremony of assent to one, end of quote, which I take to mean that you shouldn't take offense at something the bar does that you might disagree with, because you're not going to be tarnished with that. No one's going to assume that you believe that. How would you respond to that statement?
So I think you can certainly recognize that it's not as significant of an infringement on someone's First Amendment rights as it would be to force them to actually profess by word or deed their statement of belief in some orthodoxy, as was the case in Barnett. But it still is quite a significant First Amendment infringement to force someone to join an organization that engages in political and ideological advocacy. I don't think that can seriously be disputed. I mean, if they said you've got to join the Republican Party to be a practicing member of the bar, then that, of course, is going to be a significant impingement on your First Amendment rights, even if you don't have to do anything else, even if you don't have to say anything. Just the forcing of joining an organization is, by definition, a serious infringement on your right of free association. And again, I just like to emphasize it's completely unnecessary in a case like this, because there are 20 states that regulate the practice of law and have all of these successful functions without making anybody join a bar association. So when you are looking at this completely unnecessary type of infringement on First Amendment rights, nowhere in the law does that ever just get a shrug. It's always got to be struck down because there's no need for it. You're just forcing someone to join an organization without any justification. And for that reason, we think the First Amendment cannot tolerate it.
Thank you. Your time's expired, believe it or not. Mr. Volchak.
May it please the court, Daniel Volchak for the defendants. Both of plaintiffs' challenges to the dues requirement and to the membership requirement, both are foreclosed by Supreme Court precedent. So starting with the dues requirement, the Supreme Court in Keller unanimously rejected the same claim plaintiff makes here. Keller said, and I'll quote, "The state bar may constitutionally fund activities germane to its goals out of the mandatory dues of all members." Now, as you just heard, plaintiff says that that language and other similar language in the opinion is not Keller's holding, and he has two basic arguments. So first, he says the holding in Keller, you heard it, is only what was necessary to reverse the California Supreme Court. But plaintiff cites no authority for the proposition that a case's holding is only what was necessary to reverse. And I submit we know that that's wrong. For example, this court sometimes addresses issues that a district court didn't reach at all. It's surely not the case that whenever this court does that, everything the court says on an issue the district court didn't reach is dicta. Again, plaintiff offers no authority for that. Now, there is authority saying that a holding is only what was necessary to the result. But the result and reversal are not the same thing. Plaintiff equates them, but Keller itself shows that they are not the same. The result in Keller was not just that the California Supreme Court was reversed. The result was that the First Amendment challenge to the dues requirement failed. Plaintiff tries mightily in his briefing not to say that, but he finally does on page 29 of his opening brief. So the result was that the bar dues were constitutional. Now, plaintiff again tries to avoid this by saying repeatedly, and he said it again this morning, that the U.S. Supreme Court ruled for the plaintiffs. I am quite sure that Eddie Keller and the other plaintiffs in Keller disagree with that. They won on the threshold question of whether bar speech is government speech, but they lost on the underlying issue of whether bar dues are constitutional as long as a bar has the Teachers versus Hudson procedures in place. So plaintiffs claim that Keller's holding is limited to what is necessary to reverse. Again, no authority, and it's wrong.
Well, let me ask you about the penultimate paragraph of Keller, because it seems to me it clearly leaves open the claim being made here. So, well, maybe if you're very familiar with it, well, let me read it for the benefit of everybody. It'll take a minute. Justice, this is a unanimous opinion, and this is what the opinion says. In addition to their claim for relief based on respondents' use of the mandatory dues, petitioner's complaint also requested an injunction prohibiting the state bar from using its name to advance political and ideological causes or beliefs. This request for relief appears to implicate a much broader freedom of association claim than was at issue in Lathrop. Petitioners challenge not only their compelled financial support of group activities, but urge that they cannot be compelled to associate with an organization that engages in political or ideological activities beyond those for which mandatory financial support is justified under the principles of Lathrop and Abood. The California courts did not address this claim, and we declined to do so in the first instance. The state courts remain free, of course, to consider this issue on remand. Isn't that at least one of the issues raised in this case?
So a threshold response, Judge Hartz, what I was talking about at the outset of my argument was the plaintiff's challenge to the dues requirement. This paragraph you read goes to the membership requirement, and I'm happy to address that now. I hope to get back to the dues.
Go ahead. I'm sorry. I wanted to make sure. You can talk about the dues thing, then we can switch to membership if you'd like.
Very good, Your Honor. I will then proceed with plaintiff's second argument about Keller's holding and why it does not foreclose his dues challenge. That is his free speech challenge. So he says, you heard it, that what Keller held is that the First Amendment rule for mandatory bar dues blindly tracks forever the First Amendment rule for mandatory union dues. Now, there are several fatal problems with that characterization of Keller's holding. First, there is no case support for it. Keller has been cited about 250 times by courts, yet plaintiff doesn't cite one case embracing his reading of Keller's holding. So no case saying that the holding was that the First Amendment rule for mandatory bar dues tracks forever the First Amendment rule for mandatory union dues. There is just no authority for that reading, and there's ample contrary authority, including cases from the Supreme Court. There's the Southworth case that we cite. There is the Harris versus Quinn case that we cite. Both of those cases describe Keller's holding as we do. In fact, Southworth said that in Keller, quote, we held that lawyers admitted to practice in California could be required to join a state bar association and to fund activities germane to the association's mission. That's flatly inconsistent with plaintiff's argument here about what Keller held. Now, in his reply brief, plaintiff offers various responses to Harris and Southworth and all of the other Court of Appeals and district court cases we cite.
Just repeat that case. I don't want to cite, but just that last Supreme Court case. I just didn't write it. Just the
Board of Regents versus It's Board of Regents versus Southworth, and it's page 231 of the opinion. It is cited in our brief and in the reply brief as well, Your Honors.
Yes, I just didn't have the case written down. Yeah.
So, Your Honor, plaintiff's responses to all the cases we cite, including Southworth and Harris, I would disagree with the responses on their merit, but the point is what they don't say. They ignore that the court did not describe Keller's holding the way plaintiff describes it. And that's the whole dispute here, Your Honors, right? Everyone agrees the language in Keller we point to, the language in Keller that plaintiff points to, it's all in the opinion. The question is, what was the holding? Southworth and Harris versus Quinn both describe the holding the way we describe it, as did, for that matter, if you want to look at beyond majority opinions to the most recent Supreme Court opinion of any kind discussing the holding. It's the dissent from denial of cert in the Jarchow case, Jarchow, also cited in the briefs. Justices Thomas and Gorsuch characterized Keller's holding just as we do. And in fact, they said that the claim, like plaintiff's claim here, was foreclosed by Keller. Again, inconsistent with his position. Now, that's the first fatal problem with plaintiff's main argument, no case support. The next problem is the holding he posits for Keller, Your Honors, would be exceedingly odd. Again, he says that Keller, rather than adopting a specific, substantive, immutable First Amendment rule for mandatory bar dues, he says Keller held that the rule just tracks forever the rule for union dues. I submit that is not how courts decide cases. They do not, when they are presented with a particular scenario or a particular set of circumstances, say the rule for this scenario tracks the rule for another scenario. And plaintiff cites no other case with such a holding. So his position would apparently make Keller unique in all of American history. And Your Honors, if you want to see just how odd the holding that he posits would be, under his position, if Keller itself, that same case, came before the Supreme Court today, the court under his position would say, we adhere to the holding and therefore reach the opposite result that we did in Keller. Right? Same holding, First Amendment rule for bar dues tracks the First Amendment rule for union dues, but the opposite result because of, according to plaintiff, Janus. That, I submit, would be bizarre, and I submit it's why no court has ever adopted plaintiff's reading. The last problem, it's even odder, Your Honors. Plaintiff does not just say that the bar dues standard, the bar dues rule tracks union dues. He says the bar dues what I should say is that the court in Keller, the sentence he's relying on, did not just say the same constitutional rule as union dues. It says the same constitutional rule applies as public and private union dues. Now, plaintiff said this morning in his argument just public union, but the sentence he relies on ends with unions representing public and private employees. So his position is that the bar dues rule tracks two other rules, public union and private union. And of course, that raises the problem of what if those two other rules diverge? Which does Keller's holding track, or which does the bar dues rule track? It's not a hypothetical scenario, Your Honors. It has happened. Janus overruled Abood and changed the rule for public union dues, but it did not overrule a different case called Ellis, which is discussed in Keller, which set the rule for private union dues. In fact, Janus made clear that, and I will quote Janus, a very different First Amendment question arises, end quote, with public union dues and private union dues. That's page 2479 of the Janus opinion in the Supreme Court Reporter. Now, Your Honors, the point is not that this court should decide whether the rule for bar dues tracks public union or private unions. The point is that plaintiff cannot be right in saying that Keller held that the First Amendment rule for bar dues blindly tracks forever the First Amendment rule for union dues. So his creative characterization of Keller's holding is wrong, cited by no authority, and under Keller's actual holding, as described by Southworth, as described by Harris versus Quinn, his dues challenge is foreclosed. Now, Judge Hartz, I want to turn to the membership challenge. And if I can just lay a little bit of groundwork, Supreme Court in Lathrop rejected the same challenge. Plaintiff in that case said he did not want to be forced to associate with a state bar that he said engaged in what he called political and propaganda activity. So plaintiff's argument this morning that Lathrop was just about membership and a bar that engaged in activities everyone agrees is proper and not political or ideological speech is flatly refuted by the opinion itself. And as to the membership claim, Lathrop said, quote, "We are unable to find any impingement upon protected rights of association." Now, that was a plurality opinion for 4 justices, but as Keller later said, 2 other justices would have gone even further in rejecting the free association claim. So the plurality opinion is actually the controlling opinion, the narrowest opinion.
And if we just had Lathrop, that would be good. But then we've got Keller later saying it's still an open issue.
So that is one of plaintiff's 2 arguments that as to why his claim is not foreclosed. And it's the same question Judge Hartz was asking. So let me go to that one first. I do want to come back. Good. I do want to go to his argument premised on Lathrop itself. But he says, as Judge Hartz read, the court left open in Keller a question at the end. Now, there are 2 reasons that doesn't help plaintiff. Plaintiff says that what was left open was the question of mandatory membership in a state bar that engages in non-germane activity. And he says that's his claim here. Both parts of that are wrong, and either one is enough to defeat his claim. That is, that I submit is not what Keller was reserving. And number two, if it was, as the court was discussing with Mr. Dick this morning, the amended complaint does not plausibly allege any non-germane expression by the Oklahoma Bar Association, certainly not within the statute of limitations, right? As was being discussed, what's alleged is two categories of things, really. The engagement in lobbying activity regarding legislation, which we know from Keller and Lathrop is okay as long as the subject matter is germane. And here it is, because the two pieces of legislation discussed in the complaint are about tort reform and about the selection of members of the Judicial Nominating Commission. So that's the first category. That's all germane. Second category is the Oklahoma Bar Association journal articles. And all of them, certainly again within the 2-year limitations period, as was being discussed, are all germane. They're mostly about campaign finance, which is germane because Oklahoma's judges and justices stand for election. So there is no plausible allegation in this complaint that the Oklahoma Bar Association engages in non-germane expression. So even if Keller reserved the claim that plaintiff says, it doesn't matter. He has not alleged that claim here. He might point to paragraph 113. That's a bare legal conclusion. All it says is the Oklahoma Bar Association engages in non-germane expression. There aren't any factual allegations to back that up. And Iqbal and Twombly from the Supreme Court tell us that a bare recitation, formulaic recitation of the elements of a cause of action is not enough to plead a plausible claim for relief. Now, I do want to go to his argument based on Lathrop because you also heard it this morning. He says Lathrop didn't fully resolve the membership challenge because of the gap in the record about whether the state bar used the mandatory dues to fund the expressive activity. Two reasons I submit you know that argument is wrong. First of all, the language he's pointing to comes from the court's discussion about the dues challenge, about the free speech challenge. It is true. The plurality pointed to that gap in the record as a reason not to address the dues challenge, which is what Keller later addressed. And Keller says all this. But Lathrop fully resolved the membership challenge, the free association challenge that was presented there. So the first reason is that he's drawing language from an entirely different part of the opinion to say that it didn't resolve the membership challenge. The second reason you know he's wrong, Your Honors, is that it would not have made any sense for the court to point to that gap in the record as a reason not to address the free association challenge, right? Again, the gap in the record was, did the state bar use the mandatory dues to fund the expressive activity? That doesn't bear on a membership challenge. That bears on a free speech challenge, on a dues challenge. Plaintiff says this himself on page 10 of his reply brief, and he said it again this morning when he talked about being forced to join the Republican Party, right? If there were a free association challenge here, it would not be a defense to say, well, you're forced to join and we engage in expressive activity, but we're not using your money to pay for it. That would not be a defense. That would be a defense to a free speech challenge, a challenge to the dues requirement. It would not make sense to point to that gap in the record as a reason not to address the membership challenge. The plurality did not point to that gap in the record as a reason to not address the membership challenge. It did address the membership challenge. It fully resolved it. It is the same challenge that plaintiff brings here. And the last point I'll make, I said there were two reasons on the Keller paragraph. Number one is that he doesn't allege non-germane activity. The other is, I submit that is not what Keller was reserving. And it would have been odd for the court to do that because it said in Keller itself, lawyers practicing in the state may be required to join and pay dues to the state bar. That's the opening paragraph of the opinion. And it said the same thing later on page 13, talking about the reasons for the compelled association. What Keller was addressing, or Keller was reserving, I should say, was a claim that went beyond Lathrop. That's what the paragraph says, as Judge Hartz read. So to finish my answer to Judge Hartz, the claim that Keller was reserving was a claim that went beyond Lathrop. A claim, and what was the claim in Lathrop? Well, Lathrop tells us. Lathrop was a claim in which, quote unquote, the bulk of the state bar's activities, the bulk was the phrase that the plurality used. The bulk of the bar's activities were germane, were legitimate for a bar. In other words, and Lathrop also said this, it was not a case in which the bar was alleged to be a sham, quote unquote sham was the plurality's words. So to make a claim that goes beyond Lathrop, to make the claim that Keller reserved, a plaintiff must allege that a bar is essentially a sham, or at least that the bulk.
Wait. But let me read that sentence, one sentence from that paragraph. I don't think that's, you fairly characterized what the court was reserving. It says, petitioners challenge not only their compelled financial support of group activities, but urge that they cannot be compelled to associate with an organization that engages in political or ideological activities beyond those for which mandatory financial support is justified under the principles of Lathrop and Abood. That's much narrower than saying it's a sham organization, much, much narrower.
Well, so Judge Hartz, the language I'm focusing on and why we submit what I said a moment ago is, a claim that goes beyond the claim in Lathrop and Keller. Now, I want to be clear, even if agrees with plaintiff's characterization of what Keller reserved, as I said a moment ago, the amended complaint does not make any such allegation. And the last point I'll make, my time is up, but to finish my answer, it would be quite odd if that were what Keller reserved, given the language I read a moment ago, quite clearly showing, and Keller was no doubt a case in which there was non-germane activity, gun control, nuclear weapons free zone. It would be very odd if Keller had reserved that claim. We asked the court to affirm.
Well, I'm going to ask you some more questions.
Oh, certainly, Judge Hartz.
We reserve a lot of things because we hadn't thought about it, that weren't briefed, even though the record makes clear that we could have, there's record support for it. But let me ask you how you feel on the merits of the issue. But let's assume it's preserved. Do you think that you can compel a lawyer to belong to a bar association that takes positions on ideological and political issues that go beyond educating the bar, making sure members are ethical and things like that?
Yes, and I want to expand on that direct answer, Judge Hartz, but I have to give a threshold answer, which is that our position is that if the court disagrees that Lathrop and Keller foreclosed this claim, it should remand to the district court. That was all that the district court decided, and those are the only issues that plaintiff presented in his opening brief for appeal. So we have not argued this, but I want to address your question fully. The answer is yes. It goes in part because what was asked to plaintiff's counsel, the observation from Justice Hartz in Lathrop, which is that free association principles show, and this is in later cases like Roberts versus USJCs that plaintiff cites, there's only a free association violation if one could if the public, if an observer could reasonably attribute the objected to expression to the person who's objecting. And that's clearly not the case here. As Justice Harlan said, no one thinks that every member of the bar agrees with everything that was expressed by a state bar, including, he wasn't talking about this, but including in its bar journals. So yes, that can be done. And in fact, that we think Harris confirms that, because Harris said, applying the same exacting scrutiny, it said that its decision in Keller, which upheld this sort of compelled association, fit quite comfortably within the scheme that Harris was applying. That is exacting scrutiny. And the last point I'll make in answer to your question, if I can, Judge Hartz, is that plaintiff says we know the challenge would succeed here if it got to the merits because there are 20 other bars that use a different system. Well, that of course is not enough. The question is, do those other bars serve the relevant government interests to the same degree as the Oklahoma system? It may well be the case that those bars do not do as good a job at regulating the bar, or do not do as good a job at improving the quality of legal services in the state. I don't know that. It's not even alleged in the complaint, so it wouldn't matter. But if this case, if we ever got to the merits, that is a question that would require some further development, which is another reason the court shouldn't address it here.
Let me give you a not so hypothetical. The American Bar Association, a lot of judges believe the American Bar Association does a lot of great things for the law, educating people, supporting good things. 20 years ago, a number of, I think the great majority of appellate judges who were active in the ABA felt uncomfortable because the ABA was taking positions on a lot of issues that are litigated in the courts. And the appellate judges issued a statement saying, we are not agreeing or disagreeing with any of those positions. They did not want to be associated with that. On further consideration, a number of judges decided, you know what, I think it's probably better that I don't belong, that I'm not a member of the ABA, because too many people will think that as a member of the APA, I'm part of this, I'm endorsing it. Could you compel judges to belong to the ABA? Can you compel judges to belong to a state bar association that takes positions on ideological issues that may come before the courts? And what about attorneys who feel strongly, I may disagree with them totally, but they don't like the Missouri plan for appointing judges. They think judges should be elected, and they don't feel comfortable belonging if the bar does that. Isn't that a pretty legitimate freedom of association claim? How do you deal with that?
So Judge Hartz, I want to sort of separate out the different parts of that question. So to the extent we are talking about a state bar, and to the extent we are talking about attorneys, that is, our submission is the claim that Lathrop addressed and rejected. And essentially it said, look what is being required here. You are required to join to the extent of paying dues. You are not required to attend meetings. You are not required to vote in elections. You are not prohibited from coming out and saying, the Oklahoma Bar Association just printed this article. I completely disagree with it. It's wrong. In other words, you do not have to ascribe yourself to the views of the Oklahoma Bar Association, and you are free to disagree with that. And the court in Lathrop, the plurality plus the concurring justices, took the position that the degree of required association is such that it can be justified by the state bars and the state's interests in regulating the bar and improving the quality of legal services in the state. Now, there may be...
Well, but okay, now justify that. Wouldn't you have to make a pretty good showing that you need to allow the state bar to do that, or else you'd have to adopt the system in 20-odd states of just paying a fee as a lawyer, or the way the 10th Circuit bar works, you pay a fee which goes to educational programs, presumably. So how do you justify that?
If this were being litigated as an initial matter or as a question of first impression, yes, there would be a requirement to justify the level of compelled association based on the requisite interest and the degree of tailoring. Now, our submission, of course, is that is not being done as a question of first impression. It's resolved. But the court seemed to say, and you recall in Lathrop, the Supreme Court recounted, the plurality recounted that the Wisconsin bar, the Wisconsin Supreme Court, had for a time been a voluntary organization, and the Wisconsin Supreme Court ultimately decided it was not working. There were many attorneys were not participating, and the Wisconsin Supreme Court's view was that the requisite, intelligent, active, wide-scale membership bar that was necessary was not being achieved. Now, this would have to be litigated. Again, if this is not foreclosed by Lathrop and Keller, these issues would have to be litigated, but they don't have to be because they are foreclosed. Now, just to finish the answer to your question, if I may, Judge Hart, the ABA is, of course, somewhat differently situated. It is not a state organization. It is not backed up by the power of the state and hence not claiming to be furthering state interests. So it's in a little bit of a different box, but certainly as to state bars and the claim that is being alleged here as to attorneys, that is foreclosed by Lathrop and Keller. We ask the court to affirm.
Any questions by other members of the panel?
Oh, there's so many questions. So
I'm going to give Mr. Dick 2 minutes. He got 2 minutes less extra than, and nobody, the attorneys aren't responsible for having gone over. That was.
Thank you very much, Honor. I'm happy for whatever time you'll give me. Just 3 quick points that I think will be helpful to the court. One, with respect to what the result of Keller was, I think it's just clear what the result was. The plaintiffs got everything they were asking for. The plaintiffs in that case were arguing for the Abood rule and to overturn the California Supreme Court's decision. They got exactly what they want. I don't know why Mr. Volchuk says Eddie Keller thought he lost the case. He got everything he wanted. He got relief in overturning the California Supreme Court. He got the Abood rule that he asked for. Given that he prevailed on all of his arguments, there couldn't have been any holding rejecting any portion of his First Amendment claim. On the second point, he says it would be odd to tie together the rule between mandatory bar associations and union dues. in particular because public sector and private sector dues have different rules. That's wrong. I mean, what is happening is you're just saying that the usual First Amendment rule applies to all of these different contexts. There's nothing odd about that, saying because it's a private entity, the usual First Amendment rule should apply. And with respect to the First Amendment, that is when you force somebody to join and pay money to an organization engaged in advocacy, you have to justify that under exacting scrutiny. There's not a different rule for private and public sector unions. It's the same First Amendment rule, which is if there is state action involved forcing you to do this, then exacting scrutiny applies. The difference between public and private sector unions is there is no state action in the private sector context, and that's why you don't get the exacting scrutiny that applies. But it's the same First Amendment rule that in the presence of state action, you do have to satisfy exacting scrutiny. There's no question that there is state action in this case, just as there is in the public sector union case. Finally, Mr. Volchak says that Lathrop did not address the membership issue, or excuse me, he said that it did not address the dues issue, it only addressed the membership issue. But the reason that argument doesn't work is because what the court said it wasn't addressing was whether you can force someone to pay money to support an organization engaged in these other activities, which was the dues question. But the membership question is tied to that, because the membership question is whether you can force someone to join an organization that engages in the type of activities that the court said it wasn't going to address whether the organization was engaged in there. So in other words, that question was not resolved because the court did not consider whether the Bar Association in Lathrop was engaged in non-germane activities that the plaintiff objected to. And the membership question is whether you can be forced to do that.
Your time has expired.
Thank you very much.
I interrupt you in the middle of a sentence, but the sentence took about a minute and a half. So
I apologize. But we asked the court to reverse.
Case is submitted. Counsel are excused. I'm going to tell a little story. Don't mind. You reminded me of it, Mr. Dick, when you said hope springs eternal. Someone I know was one of the attorneys who argued Gideon versus Wainwright. And one of they had a lot of amicus arguments by state attorneys general. And one was arguing that you shouldn't require the appointment of counsel for accused felons. And Justice Marshall said, now, counsel, you really don't believe that we're going to rule that way, do you? And the attorney responded, Your Honor, hope springs eternal, which is probably the best argument he could make in that case. Okay, court will be in recess. I don't know if courtroom 3 is being used tomorrow, but I think it is, until 9 tomorrow. And it's 12:26. Why don't we plan to conference at 12?